documents to us.
Yes.
Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there was some financial documents that are not redacted, and so those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably
Let's go through the binder
sensitive.
one page at a time, one by one.
As far as
Next
Mr.
page.
Roman is concerned,
Next
is he given you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but not
Okay.
all.
Okay.
And I recognize that the general public will be hearing some of this, or either now
Oh,
or
yeah.
later.
Oh, yeah, right now.
Tell me a little bit about when you're talking about states discovery. What do you mean by that? I know, but
Right.
everybody else may not.
Yeah, definitely. So we have a statute in Georgia that allows us to do what called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this
Brady
case,
material.
there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that.
Yeah.
But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents. The documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay.
Using
And
their
out of these
investigators.
documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client, some of those have been deemed to be sensitive and that are not freely disseminated?
Yes, yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state.
Nice,
And nothing was
okay.
subject to that protective order. I went through and was very clear on that.
Very good.
And I'm wanting to make sure of this because this
have a lot of
committee has
leeway to
made it
talk
clear
about
from the
whatever.
beginning, it is not our intent in any way to interfere with the criminal prosecutions. And so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order
Sure.
protecting, so I did not disclose any of
Yeah,
those
or
documents.
jeopardize the underlying case, get sanctioned or
So
something.
tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time it was Chief Judge, I believe it was Judge Brasher, who was the Chief Judge at the time, obtained an order to impanel a special purpose grand jury. And I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury, and so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
Yeah, I've been practicing here a long, long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently,
this is Trump.
or
This is
a
very
subsequent
unique
grand jury as to
situation,
whether
you know.
there's evidence to
Democracy.
prosecute. Is that essentially
Historic.
what it did?
That is exactly what it did, yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they used the grand jury process, a special purpose grand jury process, to bring in testimony and bring in witnesses from out of state. They issued a lot of target letters to people back and forth. That there was a lot of people that were targets and then weren't targets, who testified, maybe negotiated some type of immunity, things like that, throughout that special purpose grand jury.
All orchestrated to get
And
Trump.
is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding there's a transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were
Wild.
recorded and then maybe a section wasn't recorded and then they went
Oh.
back on the record.
Missing tapes.
But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Everything's a little
Is
unique for
the
this.
state required to let you know if they've granted immunity to any witnesses that may have been utilized in this special grand jury process or in seeking the indictment?
Yes, they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and
Interesting.
forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was a back and forth over who could grant immunity, who had the power in that office to grant immunity. And that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff. And then ultimately it was Mr. Wade. And there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this.
Yeah.
I'm in charge.
He needs the bill for that
Was
work,
he
yeah.
engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order, and I can review it. I brought some of the pleadings with me, but it was authorized sometime. So he was appointed. The timeline. He was appointed in November 2021
Yes.
to work on this case.
November
It was
1st.
sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that, and then that went through several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or
Yes.
impaneled? Okay. And so he was involved from the very beginning of that process?
Yeah, that's why he wanted 19 co-defendants so he could build
Yes,
them
and he
all.
was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor.
Made up position.
I don't believe he goes
Special-
by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that, but but I don't really think independent
Independent.
counsel would be an appropriate term because he's not independent.
And
So
because
I've
he's
studied-
indicting Fannie.
I did not know
Yeah.
this before, but I've studied, the structure of
Not
the
independent.
independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel.
Very special.
And I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those, and then I can also tell you what I did to investigate that, because I had the same question. So first,
Just so you'll know why we're asking, the scope of this committee is we heard a lot of the allegations, and you, as a matter of fact, made most of them, or made
Right.
some of these public. And there's, of course, a public, outrage or uproar or concerns about some of the alleged improprieties that you have brought forth, both, within the in the system, kind of what's appropriate conduct.
Right.
And also
Out of DA
financial
Fannie's office,
improprieties.
yeah.
And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so we can independently verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system, in
it takes some
its
work there,
impartiality
Fannie's
and
gotta
its
go.
fairness. And I have looked at some of the existing statutes, but it's very sketchy, what is the real authority, and we wonder if we need statutory authority or statutory limitations. And so I'm going to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring it to. But and so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to
course you
find
did.
out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to
rare,
actually
yeah.
see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. And they pay between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for
Wow.
appointed counsel
Nathan
in
was
most
what,
counties.
$250?
And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to
Okay.
do, they would hire this part-time solicitor.
Not a
So it was someone who was
$700,000
already
bill.
a government employee, and they would pay $45 an hour for this person to do work.
Yeah, on
So those are the
salary or
only
something.
people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research.
Yeah.
Nobody does this but Fulton County.
No, of course not.
And the AG's office does it, and so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues, and so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts if there's a conflict, and if there's a conflict, you'd have to hire someone who's outside of the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have, the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners, you've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it. And it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those. And so those are who I sent all of those.
It's over 50. I
Oh,
want to say 59.
it's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant,
Did you ask if
outside
they have
counsel.
boyfriends
Yes.
too?
And out of those, only
they
3
have
of them
boyfriends?
have ever done it?
Only
or-
2.
Only 2.
Did
Only
they
2
have
had ever
boyfriends?
Fulton County is one of them.
Only 2. Well, oh yes, I'm sorry. It's 3 counting Fulton County.
Okay.
I did not send an open records to Fulton County on that because I already knew that they did it. So
Is there
yeah,
a statute that authorizes that?
there is a statute, and I cite it, if I may, I cite it in my
Yeah, you
brief.
Feel free.
Okay, thank you. I don't want to misquote it. Let's see.
That's a nice looking
So
binder.
it's 15-80-20.
Look at all the tabs, baby.
And how I came to learn that is I actually contacted the prosecuting attorney's counsel.
Nicely organized.
Early on in this case, and because I was trying to figure out the legality of this. I did open records and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget item in the DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
Good
That's
question.
that's what I didn't understand, and that's
Yeah.
what. I mean, in my opinion, obviously, I think that's what should happen.
She
But
has a bunch of other
the reason
prosecutors already
that it
work for
wouldn't
her.
happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 1518, 15-18. The one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000, something
What
like
is that statutory
It's,
rate?
I don't know it off the top of my head, but it is in the statute. I know that like District Attorney Willis, for example, I think it's around $200,000,
Yeah.
and that's one of the top paid
That's
people.
not enough, man.
So most
You can
of the
only buy so
people are
much
paid,
Grey Goose with that.
somewhere between 100 and 150,000,
Grey
something
Goose
like
is
that,
expensive.
depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So
About
to answer your question,
$700,000.
why you wouldn't just hire an assistant district attorney, first, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money, but they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special
many-
prosecutors?
No, how many assistant district attorneys?
No, I actually open records that, and it was declined. So we actually have a pending open records lawsuit, which I did bring. I asked for that. I asked for how many were hired, when they were hired, when they were fired, and they declined to give me that.
How many other DAs?
Under the Open Records Act.
could have
So
done
we
this?
ended up filing a lawsuit, and that's still pending.
Probably hundreds.
Because it just occurs to me, I think there's certainly dozens of them.
Oh, yes.
Maybe 100.
But I think 100 would be a fair
Yeah,
example,
100.
or a fair number based on, just my knowledge of it. But there's quite a few. And, if you had a certain amount of money.
Huge
that,
office.
They spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
Yeah.
Do you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion?
It's controlled by the county, and I do know, I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts, and so it's very interesting. It's kind of a
was
long
thorough.
answer, though. Depending on who you are, in Fulton County, depends on how your budget is approved. So, for example, the county attorney, if they want to hire special counsel,
That's fine.
okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county
Yeah.
Board of Commissioners and say, we need to hire this person at this rate, and they approve the rate. They monitor the bills, they do all of that stuff. So that's what happens at the county attorney's office.
Okay, the county attorney represents the county, is not prosecuting criminals like the DA does.
Correct, it's civil. So the county attorney does all civil things. In this case, they
Oh,
actually
okay.
did end up representing the
So different
DA
names.
in some of the open records
County
issues, which
attorney
is
and
a
the
whole nother
district
issue.
attorney are different things.
But so the county attorney, the civil body, they actually go and get county approval from the Board of Commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs, a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically, they go and they say, we need this for this project. We need this budgetary item, and it's approved. It comes out of their budget, though. So they're not going and asking for more money for the county attorney's budget. They're just asking to use the county money that they've already been allotted for this special counsel. The district attorney has taken a different position, and I was surprised, so I watched hundreds of hours of Board of County Commissioners meetings just to make sure that I wasn't missing anything, that she never went and asked for approval for any of these special prosecutors.
No. It was
in
COVID.
The
one of-
budget is granted through the Fulton County?
It
It's
is.
in a part of its budget?
It is. These special prosecutors have been paid a couple different ways. They were paid with state seizure money. So the first, around $100,000 of Mr. Wade's funding came from state seizure money.
Wow.
It appeared from looking at the budgets for the state seizure that fund ran out. So then it started coming from the general fund. But it was money so Ms. Willis had a budget right around the time that she hired Mr. Wade and these other special prosecutors. She went and asked for more money for a backlog. And so she was given extra money, and that money's been renewed since.
COVID money.
It was given to her to hire 55 additional personnel. And it's
Wow.
actually in the resolution. She went in front of the
Wow.
Board of County Commissioners and asked for it.
When was that? Do you know?
That
Do you
was,
have
I
handy?
do actually, because I attached it to my brief. So I know the dates of things. September 15th, 2021 is when she presented her PowerPoint to the Fulton County
Probably
Board of
use
County
Calibri as
Commissioners.
the font.
And she gave a lot of statistics about all the unindicted homicides. It was mainly about homicides. It is, there was some about sexual offenses, but it was almost all about homicides. She said that, why am I here? The great trifecta: crime is on the rise, historic mismanagement, and then the COVID backlog. And so she asked for quite a bit of money to hire additional personnel. It was, I can tell you, that year it was $780,000.
And that's in the fall of 2021, just before this special grand jury was impaneled?
Yes. So that happened, she was awarded that money September 15th, 2021, and she actually did get the resolution and the process that you would normally expect.
How much was that addition or increase to her budget?
Not to exceed $5 million.
Wow.
So she was awarded for the end of 2021, which this is September 15th. She was awarded for September until December 31st, $780,000. It said, and then the next year, not to exceed up to $5 million.
So hang on for 1 minute. My vice chairman here, Chairman Dolezal, is way more high-tech oriented than I am.
Okay.
He has downloaded some of your documents that you produced to us that I had asked him to have available so we could see them here.
Let's get to the
And I
documents.
think you have produced to us this PowerPoint presentation that Ms. Willis made to the county commission in September of '21 to allegedly fund backlog of murder cases, et cetera.
Yes,
right?
that would be Exhibit A to that motion. Yes,
Okay.
that's it.
And is that what we have on the screen here? Let's see if we can flip this one right.
It is.
Okay, so this is part of her PowerPoint presentation for additional funding over and above her previously appropriated budget from the county?
7 million for a COVID backlog,
Yes.
what we need.
Yes, it is.
7.5
All
million
right, so
budget.
what were the county procedures for approval of funding for, additional outside counsel, or in this case, it sounded like she was going to hire 55 people in-house to help with the backlog. Does the county have guidelines or rules or regulations as to how you get funding approved for either additional staff to work on her backlog of homicides or for special counsel to assist you?
Oh, yeah. Yes.
What are those proper procedures?
You have to get approval by the Board of County Commissioners. And the statute that I cited originally, 1820, that statute actually is the one that it says that you can hire additional personnel like this, but it has to have county approval. So, the statute says it already. When you were asking about changing statutes, it's clear in the statute that it has to be approved by either local law or the governing authority, which would be the county in this place, and in this instance. And it's very specific that it can't be paid with state funds.
Anything in that September 15th of 2021 proposal or request for funding that addressed or contemplated special counsel to pursue indictments against folks for election fraud?
No, not at all. And I watched the
Wasn't on
video.
the
It's
list.
online. Her speech, where she used the PowerPoint in the speech. There's nothing about that at all. And in fact, what was submitted was pretty specific. It was to hire 55 new employees, not contractors, employees.
Nathan got that money.
In November 2021 and December 2021. And I did open records based on this, asking who was hired and the dates of hire, because I wanted to be able to track that, and that was denied.
And who made that denial, the DA's office or the county?
The DA's office. And I did bring the open records lawsuit, just in case you had any questions about that.
Danny is covering up.
So it was the county, and I can tell you when
Disgusting.
I filed it. Let me see.
Just denying the record requests.
And we went back and forth, and, I requested it several times, but it was Dexter Bond at the DA's office who sent a letter back and said, we don't have that. We don't have to give it to you.
He's like the chief assistant for Fonnie Willis.
He is, and he's also the one who went to the Board of County Commissioners whenever they needed funding. So, if they had some large printing, and they had a big rebranding campaign
Dexter Bond's
where they
in
had
trouble.
a lot of money that was spent on this rebranding, like posters and things like that around the office. And he had to go and testify in front of the Board of County Commissioners to get that paid because they were not paying it. So he's sort of the go-between with the Board of County Commissioners. His official title is something like Chief Legal Officer or something like that. But he's an attorney.
So you've gone back and reviewed all of the Fulton County Commission's minutes and records to see what requests were made and if there was a resolution granting the additional funding?
Yes. Oh, yes.
Was there ever a request for additional funding for a special prosecutor to pursue these election cases?
No, there wasn't, and I knew that before we got the district attorney's response, but subsequently we got a response from the district attorney's office that said, we didn't do it, we don't have to do it, I'm a constitutional officer.
It's our money,
So
we
their
can do
argument
what we
was, we
want.
don't have to comply with those statutes or those rules, because she's saying she's a constitutional officer, so she doesn't have to get county approval.
Fanny
She
can do
spend her
whatever she
budget however
wants all the time and no
Then why would she have
consequences.
gotten county approval for the the other 55 attorneys?
So what I've surmised is that was because those were staff members, and so she went and asked for additional budgetary money. She needed a higher budget. So for those 55 people, she went and asked for more money because she didn't have enough money. And once she was awarded that, it's her position now that she can spend that money however she wants.
What a
Doesn't
piece of
have
work,
to use
huh?
it for 55 new staff. She can use it for
Her
special
boyfriend.
attorney general.
Yes.
Not attorney generals.
Yeah, her
DA.
boyfriend.
Okay,
Right, yes.
counsel.
And then he can
Essentially,
take that money
that is their argument in
and
their
go on
reply briefs
vacations.
that they filed in court, that they have inherent authority, they don't have to comply with the county ordinances,
Big
don't have to
fanny.
comply with the statute.
So they don't have to comply with our state statute.
So,
That they have,
Big fanny,
once they're
man.
awarded the budget, they can use that budget however. I mean, how their motion, and I'm happy to send the motion, it's public record, but how their motion argued it was, if they get $5 million, they can pay that to one person if they want, as long
believe
as
that.
because the voters authorized her to do that. So the county, or their position is the county authorizes a budget,
Wow.
and she can pretty much has inherent authority to do it however.
Even though she specifically asked for the money to prosecute backlogged homicide cases in Atlanta.
the old
Yes.
bait and switch.
What's your opinion on that? You think the statute or county procedures permit that?
No, I do not. And I cited several different county ordinances. So when I read the statute, when I read 15-1820, and it makes sense, it makes sense intuitively. As lawyers, when we bill, someone is reviewing our bills. I mean,
Yes.
that's just, that's the process. If you're in
Unless
private
you're Fannie.
practice, your client authorizes your bills. If you're doing public defense, which I've done public defense, I've done appointed work, the governing agency approves my bills, and they will cut them. They will regularly cut them if they're too high. And so there's always some type of budgetary authority that's reviewing everything. So I thought it was very strange that in this case there isn't one, and that there's really no oversight because it is public money.
Big
So
fan.
I know that it's an elected official, but it's still public money. And I don't live in Fulton County, so it would probably aggravate me more if I did.
Yeah, you can imagine how aggravating it is. They're
So we
going to
have a
Belize
code
and
section
Napa
up
Valley.
that you're referencing for prosecuting attorneys getting additional personnel. That's what Mr. Wade would qualify as, correct?
Yes, so under B, that's the section that authorizes the appointment of special counsel. And it says the manner and amount of compensation to be paid is fixed by either local act or by the district attorney with the approval of the county.
Yep, right there at the
And so
bottom.
that's where, that's our argument that this was not appropriate
didn't
expenditure
approve
because
it.
it did not have county approval.
That was
So our
COVID
state
money.
law requires if a DA is going to go seek outside counsel, I'm going to call them, that must be approved by the county commission.
Yes.
For
without
the
a doubt.
purpose. For the purpose.
And there are only 3 circuits that have even utilized this procedure.
Yes.
Do you have any idea what rates of pay were approved in those other judicial districts, or, whether they went through some type of approval?
So one was $40 and one was $45,
Not
and their
$250.
the annual amount that they spent did not exceed $2,000.
And what did Mr. Wade receive?
He's received about $700,000 so far,
At $250
And
an
what's he
hour.
paid per hour?
$250 an hour.
Has Fulton County been given any opportunity to approve or reject those bills, or the fact that he's even hired?
No, and that's an interesting point. So one of the things that the district attorney argued in their motions was that they don't have to have the actual bills approved. So she is the one that approves the bills.
Big
So
fanny.
essentially what happens was he would submit an invoice and she would sign off on it and send it to purchasing, and then purchasing would pay for it. So their argument in their motion was that the oversight is by purchasing saying a pay, that she would be the one that
Wow.
reviewed the time.
Our own office
So Ms.
will
Willis
review
reviews
our
the
own
time, and then it
payments.
gets submitted to purchasing, and purchasing then pays it. And so that's the oversight, in her opinion, in the state's opinion, the oversight is from purchasing, but purchasing just gets a bill and pays it. They don't actually look at it and see if the work's done.
Does Ms. Willis do that? Is she required to approve these bills submitted by the special counsel?
So the contracts indicate that the bills are submitted to her. She doesn't sign off on all of them. A lot of them were signed off on by other people in her office, purchasing people and things like that. So there's no evidence that I was able to find that she actually scrutinized these bills or reviewed them or anything like that, but she may have.
And you mentioned that attorneys that are working for state agencies or whatever, including the special assistant attorney generals, submit bills on like itemized statement on what services they've rendered?
Yes, and the Attorney General has very specific guidelines on that, what you can bill for, how you have to bill, and, you know, is told
bill
to
24 hours
remind.
in a day?
There's a reminder that this is public service. So, you know, essentially be judicious in your billing.
Right, you go voluntarily get underpaid to be able to
Right.
help the public.
And a lot of people view it as public service, I think.
Are those bills submitted in like tenths of, I do some billing, you know, in my job, and it's usually tenth of an hour.
Yes.
Are there rules or guidelines or sort of standards of practice and how you bill?
Yes,
bill
so
24
most law
hours in a
firms,
day?
I know because my husband used to work at a law firm, is 6-minute increments, and that's how most lawyers bill in the private sector. Public, it appears that most of them are in 10-minute increments. I know that that's what all of the indigent defense groups, they all are 10-minute increments, but I've never seen anything above that.
Okay. And on the open records request you made to the other judicial circuits, how did those outside counsel bill?
I honestly, I would have to go back and look. They were very small bills, though. You know, they were making less than $2,000 a year, so they were small bills, and they were
About 700
project-based,
grand.
which I think is also different. You know, they would be hired to do a certain project.
If Ms. Willis had hired a employee, one of these 55 employees, and tasked them with the job of going through a special grand jury process and helping seek indictments, investigate these allegations, what's the most they could have made?
Well, first, she couldn't have hired Mr. Wade because it violates county policy, so she would not have been able to hire Mr. Wade as an employee.
How does that violate county policy?
They have a lot of policies on nepotism, relationships, personal, there's a lot of guidelines in the county policies. So she would not have been able to hire him. It would not have been approved. And that would be something that actually did have to get approved by the county. And because of their relationship, that wouldn't happen.
So she wouldn't have been allowed to hire him
If she was
because of
honest about it.
violations of other county policies?
Yes.
He couldn't have been a direct employee of the
Why she had
district
to cover
attorney's
it up.
office.
Exactly. He
This
couldn't.
Yep.
ethical obligations?
Yes, it did. So
Let's say it wasn't Mr. Wade.
So if it wasn't Mr. Wade and someone else, I believe most of the other prosecutors on this case make around $175,000 annually.
I interrupted you, I'm sorry.
That's okay. No, that was the
Good.
answer.
Why they
So,
had to
you
go
know,
away around the rules.
if she had hired Mr. Wade or somebody else as a salaried employee, they would make around $175,000, most likely.
So using this technique that didn't obtain approval and didn't have to follow the ethical guidelines of her own office, she was able to pay him $700,000 over 2 or 3 years.
Yes, and
Way more than he would have made as an employee.
way more, and also he's able to have a private practice, which is significant because you're not able to have a private practice if you're an employee. So that's a big issue.
Have you reviewed his billings?
Yes, I have.
So have we.
Senator Dolzall, will you give
White
us
House
an example
counsel,
of one? I think we have one, we're just going to
24
pull up
hours in a day.
randomly, kind of,
Okay.
okay, is that an example
Here's
of
one.
the type of invoices he would submit?
Bingo.
Yes, it is, and so.
That's an actual one, isn't it?
That is an actual one, and so there's a couple things on this. You asked earlier about the authorization, that stamp that says okay to pay. I believe that's Dexter Bond's signature. So that was one where, you know, Ms. Willis didn't approve it or didn't review it, at least
35
as far as we know
grand,
from the
even.
signatures.
But her chief legal officer did.
Right, so they would do that stamp, okay to pay, sign it, and then send it to purchasing. But yes, this is one of the bills, and so he had monthly caps, which
racket.
went up. There were a couple different contracts that were renewed. So he had one contract that expired, another contract, and the monthly cap was $35,000 a month.
and he hit it.
So that's, you know, that's where you
35,
see the
35,
total.
35,
But this billing is not something that you would normally see.
All right, well, I'm noticing it lists the day and just a number of hours. There's no real itemization of exactly how much
Nothing.
time you spend doing
10
whatever
grand
type of
travel.
task.
Right, there's none at all. And I tried to I also open records, because in Fulton County you have a badge to access everywhere. So I didn't open records for his badge access. I was told he didn't
Wow.
have a badge.
Oh, my
I
God.
was told by other witnesses that he did. So, you know, I don't know, but that you would, if you were doing these things in the office, you would. I used to be a Fulton County employee. You have to scan, and they keep track of all of that. So you have to scan your badge to get in to certain places. So if he's doing this, even as a contractor, contractors at the jail have badges.
should
The
corroborate it.
medical providers have badges. They all have the badges that they
She is
scan. I
thorough,
open
man.
records
Wow.
to the sheriff and the DA's office, and both of them told me that he did not have a card, an access card. But in order to do this, I would assume he would have to have one to get into the DA's office. And I have been told that he had one, and those would be able, you would be able to see when he went in and out.
Sure. Did
But I
he
was
even
denied that.
did he even go into the office?
Anything unusual or irregular about, this is just an example, Bill, about the way he billed the county?
Completely. I mean, this is, you would never see this. This is what I would call block billing. So it's, I mean, one of them, for example, it's 28 hours
10
over the
grand.
course of 2 or 3 days. Team investigation meeting
And
and
drafting.
drafting. I went back and looked to try and see, a lot of these were like drafting. And
Review of PowerPoint. Look at that one at the bottom.
at the time, I'm not sure what would have been drafted because most of this was during the special purpose grand jury. So
PowerPoint
there's not
review.
really a whole lot of drafting.
16 hours.
And, we've obviously never seen anything that he specifically has drafted. But I also calculated these team investigation meetings. So the majority of the billing are things like meeting with team. So if you see here, it's got team investigation meeting. Then it's got team meeting and argument prep. And then meeting with team. Most of his billing is meeting with team. Team meeting, team investigation,
Whatever.
team brain drain. He called it different things like that. But I went through, and I mean, that's the majority of the bill.
Hanging out. Just hanging out, talking about the case.
This wouldn't be standard from what you see at block bill in 8-hour increments instead of, you said, 6-minute increments or
No.
more specifically, and does not really give a lot of identification of what's being done.
It gives pretty much zero, in my opinion, identification. I mean, this
Yeah.
is not something that we would be able to submit to a client ever.
10 grand over
I can't
4
imagine. I
days.
mean, they would, if I billed them $2,000 for 8 hours of meeting with a team on one day, and just research without what I'm researching. I mean, you have to be detailed in your bills because that's accountability. I mean, that's the only way as lawyers we can be accountable. Our clients aren't sitting in our office while we're researching. So I have to say what I'm doing.
And somebody has to approve it.
Oh, yeah.
And it's ultimately Fonnie Willis that was approving these either personally or through her designated assistants.
Yes, yes.
And there was a written contract with Mr. Wade and the Fulton County DA's office?
There was, yes.
All right, let's see if we can pull that up, Senator Dolezal. Am I right that there were, I think I've reviewed your documents, that there were more than one contract?
Yes, there were.
Is this the first one?
Yes, that's the first one.
All right, so that says it shall commence November 1st of 2021 and go through October 31st of '22.
Yes,
Okay, so that contract began before there was even authorization to have a special grand jury and later in November of '21?
yes, it did.
Okay. Does it specify that that's what his role was going to be? Or is there any way that's disclosed to the public, what he was doing?
No, up at the top, I believe it says, let's see, it just says attorney consultant. This one, so if you look under whereas, the first whereas, it says to provide legal services regarding anti-corruption matters. So, the head of the anti-corruption unit is a lady named Sonia Allen, and she was the one that was originally in the emails that I talked about earlier,
Sorry,
negotiating immunity and things like that. So she's the head of that unit.
But she
So
wasn't
the
sleeping with
DA's
Fannie,
office
though.
has their own special anti-corruption unit already in-house?
They do, and they have a director of that. Sonia Allen is the director, or chief assistant. She heads that unit, and she was the one that was originally on the emails negotiating immunity and things like that. And then it switched over to, there was some issue, I believe it was with Governor Kemp, on him testifying when, all of that stuff, and Mr. Wade took over and said, I'm the only one with authority. And so Ms. Allen sort of stopped working on the case, and she hasn't
Very
really worked on the case
convenient.
since.
From your experience and your knowledge of Mr. Wade and Sonia Allen, does he have any special unique experience or expertise that would make him better at this anti-corruption work than the head of the anti-corruption department in the Fulton DA's office?
No, but, I mean, other than, no, he would not, but Sonia Allen also hired Mr. Wade in Cobb County before this contract at, I think it was like $550 an hour or something,
Crazy.
to investigate deaths in the Cobb County Jail.
Took no
So
notes
Sonia
on
Allen
that.
was the chief, so when Neil Warren was the sheriff in Cobb County, Sonia Allen was the chief deputy. And so she basically ran the sheriff's office. They had a couple different deaths, and there were some lawsuits over access to that. A lot of the local lawyers wanted access to what was going on with the jail deaths. And Ms. Allen hired Nathan Wade to do that work, to do an investigation. And so a lot of this came out because they were ultimately sued. So I reviewed, part of what I did in this case was I reviewed all of those documents as well. Mr. Wade had to testify because one of the news organizations sued them and said that essentially Ms. Allen hired Mr. Wade to try to get around open records, to say that it was an open investigation so that they didn't have to give the jail recordings to
So
the families
gross.
about how these inmates died.
And he took no notes. They're
Mr.
all in
Wade
his head.
was a witness and had to testify, and he had billed a lot of money, which I don't have the figure, but I've got the invoices, but he had billed quite a bit of money to Cobb County, but hadn't produced any documents.
No.
And so he had to testify, and his testimony was that everything was in his brain. He didn't have any written documents from anything. But that's
smart.
where,
That was some years before.
that was some years, I think it was in 2020 maybe?
So
It was
when
right
did-
before
When did
this.
Miss Allen get hired by the Fulton DA's office?
When Miss Willis took office. So when Miss Willis took office was the same time that Mr. Warren, who was Miss Allen's boss, was no longer the sheriff in Cobb County. So a new sheriff was elected, Craig Owens, and so he was elected in Cobb County. He took over that office. Miss Allen no longer had a job, and she was hired by Miss Willis to head the anti-corruption unit.
Okay.
All her little acolytes,
So-
installing them and then hiring
From
them
your
to
documents
hire
you
other
produced and
acolytes.
your news stories that I've read it, apparently there were other special counsel that were hired by Miss Willis?
Yes.
And to work on these specific RICO cases or election fraud cases?
Yeah, the white guy
Yes,
and
so
the white
there's
woman.
several, and so that's kind of a longer answer because there's a couple different classifications. Mr. Wade was, at the time that he got this contract, he was law partners with a gentleman named Terrence Bradley and another gentleman named Chris Campbell. So it was a three lawyer firm. Both Mr. Wade and Mr. Campbell had contracts also. They actually had contracts before Mr. Wade. So they both got contracts the month that Ms. Willis took office. They got contracts to do what's called taint work, which is essentially if, for anti-corruption, because it's a lot of police brutality cases, if there's things that could be considered privilege. So let's say the police union had a lawyer doing an investigation, they subpoenaed those records, those are privileged. Somebody has to review those to see what the DA's office can actually see. So it's that wall, that privilege wall sort of. So both of Mr. Wade's law partners had contracts to do that privilege review, that taint review, conflict review.
So you're seeing if there's tainted evidence, something that should not be revealed might damage another case, or it might be privileged and not subject to disclosure?
Right, exactly. And one of the best examples I could give is, in the Tex MacGyver case, he was a lawyer. They seized a lot of his documents. A lot of them were attorney-client privilege related to other people. The DA's office was not able to just go through all of those, so they had to have a taint team, is what they call it. And so that taint team, and I don't know which cases, but the taint team involved Mr. Bradley and Mr. Campbell, who were Mr. Wade's law partners.
Basically, they're reviewing documents to see whether they should be produced or privileged by attorney-client privilege or something else.
Filtering out
Exactly.
stuff.
Not exactly prosecuting criminal cases then.
No, they weren't prosecuting criminal cases. But Mr. Wade testified that they were law partners at the time, so that he would have shared a third of whatever contracts they got. So those contracts, he was getting paid essentially from the law firm as well.
All right. So on this case, these RICO cases that you're involved in, one of them, there are other special counsel in addition to Mr. Wade?
Yes, so there's two other, on this case particularly, there's a lady named Anna Cross and a gentleman named John Floyd. And John Floyd has worked with the DA's office for many years. I actually was involved in another RICO case year before this one, which luckily my client resolved his case, so I'm no longer involved in. But that case, John Floyd had also helped craft the indictment. And, he's sort of known as a go-to person for racketeering cases, so the district attorney would regularly call on him to help
He
in
wrote the
drafting
book.
indictment. Anytime we would file what's called a demur, which is a motion to quash an indictment, he would usually be the one that came and argued it. And then Anna Cross was also hired, and she really focused on the work in federal court. And both of those sort of make sense to me because Fulton County prosecutors they're not necessarily barred in federal court. It's not something that would be required for your job. When I was a public defender in Fulton County, I wasn't barred in federal court. I had no need to. I wouldn't have paid the dues, wouldn't have done that. So, it's not something that would be required for their job, but Ms. Cross is experienced in that. So she was hired sort of as a subject matter expert to litigate some of the federal removal issues in this case.
Did those two individuals have contracts with the DA's office as well?
They have had contracts historically. They do not currently have contracts. It's very odd.
Did you review their billings?
I did. I reviewed their billings. Stark contrast. So
Yes, big
Mr.
deal.
Floyd, for example, he was only paid at a rate of $150 an hour.
The guy who
And
wrote
he's-
the book.
Case.
Same case. And
White
he,
guy.
More experience and expertise in RICO cases.
I mean, everybody would agree. I think that John Floyd is one of the preeminent experts on RICO.
Yeah.
I believe he testified in front of the Georgia legislature when RICO was passed.
And he wrote the
Did he
book.
have to submit itemized invoices?
He did, and his were very different. His were significantly reduced, and the big difference was he billed for the time that he was working on the case, not necessarily like 8 hours for team meetings and
Did he
things
have
like that.
itemized billings?
Very much so,
And then
yes.
what increments did he bill in?
I might have some of his contracts with me, but it was either 10 or 15-minute increments. And so did Anna Cross. Now, Anna Cross was paid $250 an hour. Anna Cross is very well-known, very experienced appellate, federal lawyer, does a lot of complex litigation. She was a DA for many years, handled a lot of high-profile cases for the district
She got
district
$250
attorney's
an
office.
hour.
I mean, I know her back from when, we did death penalty work in Cobb County together 15 years ago. And then she went to DeKalb County and prosecuted a number of high-profile cases there, but just very well-known. And her bills were also submitted, but they were the same rate. They were $250 an hour, but they were much lower bills, not anywhere near the bills that Mr. Wade did.
Do you know how much Anna Cross has received during the course of this criminal prosecutions or
I'm not sure.
investigations?
I might. Let's see.
Okay. You said Mr. Wade had
They're
about
much lower.
700,000 so far?
Yeah. Oh, Miss Cross was under 100,000, I believe.
Under 100
So if
grand.
she's under 100,000, what about Mr. Floyd?
Mr. Floyd, much lower, even lower than Anna Cross. He has not billed in a while, so I've subpoenaed, or not subpoenaed, I did subpoena, but I also did open records for all of his bills. We've not been provided anything recently from him, so I'm not sure if he actually did bill, because his contract said you have to submit the bill within a certain amount of time. So I'm not really sure. They stopped responding to my open records requests, but when they did respond, they were very, very limited, very small bills.
Of course.
Okay. And your open records request was to whom? The Fulton County government, the commission, or the DA's office?
I did them to all of them, and once especially that they stopped responding to them. So they have a portal, and if you go to the DA's office and you click open records, it takes you to the Fulton County portal. So if you try to submit it to the DA's office, it necessarily goes to a portal for the entire county. So you have to submit it through those. So that's where I would submit it. You can designate, I think this is the DA, I think this is budget, things like that. So I would be over-inclusive just to make sure that I wasn't missing somebody. But every single time they would route it to the DA's office. So I would get a response that said it's been routed to the DA's office and, we're waiting on the
don't have
response.
anything, right?
There were one or two that I got from the county that didn't appear to be routed to the DA's office.
And so who's refusing to produce these records to you?
The letter came from Dexter Bonds at the DA's office.
And
Dexter
that's
Bond.
why you filed a lawsuit against the DA's office to force them to comply with open records?
Yes.
Okay, that's still pending?
It is still pending.
Fulton County Superior Court?
It's Fulton County Superior Court. It's assigned to Judge Kraus, I believe, and the county attorney contacted us and says they're going to be responding. So the county attorney is actually defending that lawsuit.
Right. And so they're telling you they're going to respond to the case or respond to the request now? You're waiting
I
to
believe the
see.
case. I haven't received any documents, so.
Fairly recent filing you filed there, or that lawsuit?
Yeah, so we filed it in January, and then they had a little shutdown in Fulton County where nothing was able to be file stamped. Our process server couldn't serve it until it was file stamped, and the Odyssey, the e-file system in Fulton County was hacked, and so it was shut down for a while. So it took us a little bit of time to get a file stamped copy back, but it's now been served. But it was filed on January 30th,
Of 2024.
2024, and I have a copy, which
I don't have that.
I-
If you would provide us with
Happy
that, then
to.
we'll give it to the Secretary of the Senate as a supplemental response to the subpoena.
I'm happy to. This is a clean copy.
Okay?
She
Yes,
has
so
it
you
all
all
in
can-
order.
So
It's
what's the
amazing.
relevance
This.
to you? Why did you seek these billing records of these attorneys?
I wanted to compare the different billing, the different styles of billing. Also, there had been an allegation that I was singling out Mr. Wade, and so I thought it was relevant to see the rates that the other attorneys were paid, their billing, what type of billing, if they billed for everything. Just for example, when we're in court, one of the prosecutors may be arguing, Mr. Floyd and Ms. Cross aren't there billing. But Mr. Wade is always there. So that was one thing that I noticed. And I understand now that their response is that he sort of is like a case manager almost. So I guess that would be why he's always there. But I wanted to compare them and see.
Okay. I think I want to show a couple of things.
So that was some really good
Senator
foundation.
Dolezal, I want to show some of the other billing records, particularly ones that showed the trips to D.C.
Washington, D.C. Yeah, and we might have.
We hadn't had but a couple of days to review all your documents, and I skimmed these records because I wanted to know exactly what was going on. You'll see highlighted down here at the bottom on November 18th of 22, interview with D.C. White House, 8 hours. Do you know what that references?
Based on another motion that was filed in our case and the arguments that were made by the DA's office, I believe that was when they met with the Department of Justice. They met with the January 6th committee. So one of the co-defendants filed a motion
What'd they have to do that
try and
for?
get some documents, and the state had to respond. It was a motion to compel. I was there for it. I was not. I joined it, but I didn't litigate it. And the state said that they had to meet off campus, so because they didn't have a record of it, I guess you have to have a record if you go into the White House. And so they met with the January 6th committee off campus, and they said they had a really hard time getting that meeting, and they had to have someone who had some source or something to get them to agree to the meeting.
It was a secret meeting.
So the motion to compel was based on this entry.
Yeah.
And this entry, in response, they said they were meeting with the DOJ and someone with January 6th.
There's also an entry, May 23rd, 22, travel to Athens conference with, what is that, White House?
Yes, and we've tried to figure out what and who that was,
Right here.
because there was something happening at UGA Law School, and so we just assumed that it was someone that was there, and that's why they met there. But I don't know.
Do you have reason to suspect, or can you confirm whether or not Ms. Willis or Mr. Wade were coordinating with the Biden White House in the course of this investigation and prosecution?
Great question.
I mean, the discovery, they've got, a lot of our discovery involves the January 6th. I mean, a lot of what we have in discovery is the same stuff that other places have. So they had to have gotten it from somewhere. And they also, they read a lot of the testimony. They played testimony in the special purpose grand jury. So, I don't know how they got all of that, but they got it somehow.
White House and J6 committee.
And then, there's,
Leading this whole
one of the
thing.
other things I did was I did a open records for the White House access, and we had records that Ms. Willis and the mayor of Atlanta were at meeting with the
Vice President.
vice president.
Okay, and so this is the access
There it is.
history. How does that work? The White House keeps records of anybody that comes in and has any kind of official meeting for sure.
Yes, and my understanding is it's highly regulated who can access the White House, and so you have to apply in person or apply ahead of time,
February
and then they give
24th.
you a time when you make the appointment, and they give you a time when you're allowed to be in and when you have to be out by, and they track
Fannie
you. And I mean
Willis.
that makes sense. They don't want anybody lingering in the
Meeting
White
with
House.
Vice President.
But they keep that, and so they're called WAVE records, I believe is what they're called. And I'm not
Sideline.
sure what that's an acronym for, but they're publicly available. They're open records.
And this record that's shown on the screen shows Fannie Willis was a visitor with V. POTUS. I presume that's Vice President of the United States.
Yes, it was.
And what was the date of that back in, was that February sometime of 23?
February 28th. 2023.
Is that before the indictment?
Yes.
Okay. Any further
Interesting. Meeting with Kamala.
explanation of why Ms. Willis was meeting with the Vice President of the United States?
No. I know Dexter Bonds, and I believe that's the same one that I think it's Dickinson or Dixon, the mayor of Atlanta was also there.
Yeah,
Okay.
very curious.
We're going to take a short break. We've been going at this for a while. Let's take a somewhere between 5 and 10 minute recess, and we'll be back. Thank you. We're in recess.
All right, my friends. What a heck of a morning. My goodness. Ashley Merchant is the most prepared person in America today. She had answers for everything. We had that big, nice, thick binder there with all those tabs in there, blah, 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 all the way down. And so she was just laying it out. And for those of you who are just joining us, of course, we've been covering all the Trump litigation for some time, including this Fannie Willis saga. Let's do a brief recap on what we have heard this morning. So obviously, this is Ashley Merchant. This is Mike Roman's attorney. She's the person who initiated this whole thing. And we've got some good details from her today. She walked us through a lot of the billing, a lot of her experience. Obviously, this is somebody who's very credible. She's the president of all president. Every time she says that, question, did you subpoena that? She says, yeah, I subpoenaed that and that and that and that. And I got his mom and their kids and their dog's veterinarian. I got that subpoena too. It's like, oh my gosh. And so we spent some time this morning unpacking the foundation of this entire investigation. Why, oh why, did Fannie Willis hire outside counsel? She's got a whole DA's office, a lot of other prosecutors there. It's a huge county. And so why didn't she just pick someone else who was already there working with her to go and investigate some of this stuff? Well, obviously, she's not dating anybody in her office. And even if she were, she couldn't pay them $700,000 and then grift off that to go to Belize and Napa Valley and all these other places. So she went out, got her lover, who we know from other evidence and other witnesses was here, and they were in a relationship going all the way back to 2019. So she hires this guy and brings him on the case. Now, she went to Georgia, to Fulton County, and asked for a bunch of additional money, saying we got a COVID backlog. This is right after the pandemic, and so we need to go hire 55 new prosecutors in order to go get through this backlog. Well, it turns out she didn't use any of that money for that. She just said, well, I'm big Fannie Willis. I got another $700,000 coming my way, and I can do with it as I see fit. So she turned around, gave it over to her boyfriend on September 15, 2021, right before she ultimately hired him in November. She got another $780,000. Went to Fulton County. It was not approved for election fraud. It was not approved for anything that she's using it for. But she said, I can just do it however I want. We also saw Dexter Bond is apparently somebody else at Fannie's office. And this guy was apparently stamping the bills and just approving it. And there was no oversight over any of these funds. And so Dexter Bond is now going to be also in hot water. And we heard from Ashley Merchant a lot, and there's going to be a lot more to come. And so what a beautiful morning. We're laying the foundation. We're in the Georgia Senate. This is all live. They're taking a short break, and Fannie is being exposed. And as we were saying at the beginning of this, it's very interesting to have her walk through the chronology of all the things that have happened without having the government pop up every 2 seconds. Adam Abate or Adam Cross just popping up. Objection, privilege, objection, hearsay, objection, objection. And you can just see what a scam this whole thing is. And Fannie Willis seemingly has been orchestrating it for quite some time. And so it has been an absolute heck of a morning, my friends. They're on break. While they're taking a quick break, let's say hello and see who is joining us on this beautiful day. It's grateful to have so many people joining us today. This is such an exciting and ridiculous saga, and it's a very important one. In addition to just being juicy and spicy, this may result in serious consequences, not only in the RICO case with Trump and this prosecution, but also in Fulton County. And maybe this has some, tentacles that spiral out, and people start having a closer look at Alvin Bragg or Letitia James and start questioning the true honesty and veracity of these prosecutors. But it's a beautiful day, my friends. Grateful to have you. Would love a subscribe from you if you haven't already subscribed to our channel. We're covering all of the Trump litigation, including the Florida case, the J6 case. We've got the civil litigation. We got all the immunity appeals, all the SCOTUS situation that's happening. And so thank you for joining us and subscribing. We also talked about the 4 different investigations that are currently taking place with Fani. And this is just one of them. I think there's a lot more coming down, not only in Congress, but the Georgia State Bar, the City Council. The City Council is going to be hearing about this tomorrow on a Zoom meeting. And there are 2 actual official complaints that the City Council is receiving. But this is the Senate. And so we're just getting started with Ashley Merchant. And we don't know how long this is going to go today, but she is the only witness. And we are making our way through the various prosecutors that have also been on this case. And we're asking ourselves about the billing discrepancies and why did Nathan Wade get $700 grand when Anna Cross, the white woman, and Floyd, John Floyd, also the white male, with whom Fani didn't sleep with either of them, and they got paid a lot less than he did. And so lots of questions about this, my friends, of course. But we're grateful that you are here and joining us. And it looks like we got some nice donos in the house. Oh my goodness, my friends. Let's say hello to some of these donos that came in. So we got this one on the YouTube chat. Dan S. is our newest supporter who's a member. Welcome aboard, Dan. Great to have you. Let's see if we got some comments, some questions. John McGarvey's in the house. He's saying first as he's here. Another one from John McGarvey on Rumble, also first. And John McGarvey was first on Locals, the trifecta today. And hey, we had some other comments. I know, let's see here. We had something from Knox Bierman, who's a defense attorney in Texas. Let me see if I can grab this one, because Knox was telling us about some of this case. Megan's here, says, I'm so invested. Good to see you, Megan. Glasich is here, says, for the binder fund, stop binder envy. Stop binder envy. We had this one from Andrew, says your audio is out of sync. Oh no, is it out of sync right now with my mouth right now? Kung Fu lip sync, it's not working? It's a bad sync. Huh. All right, well, let me see if I can fix this. Let me see if I can do a refresh and potentially fix this. It's out of sync? Yes, way out of sync. Okay, let me see if I can fix it. I don't know what's going to happen. I don't know what's going to happen. The screen might go black or whatever, but we're going to try to refresh and reset things while we're on break. Let's see if we can do it. Be right back. All right, my friends, we're back. Let's see. Are we a little bit better in sync? Hopefully, this is a little bit better. I just did a reboot on all the tubes. I did not reboot the computer, but we rebooted some of the tubes. Better? Whew. Okay, good. Whew. All right, good. Thank you. Thanks for the correction. Much better. All right, good. Sometimes we got to reboot the old switcher. Glad it worked. Thanks for letting me know, everybody. Very nice of you. Thank you for doing that. So Much better. Good. All right. So we'll get things in sync. You got to be in sync. Otherwise, it's like, I don't know. How's the weather today? This hearing has been very fun and exciting. Anyways, great to see everybody. So thank you for the heads up on that. That came in from Andrew the Bard. And I also know Steph D said that too. Thank you, Steph D. Says, can you restart? We restarted. Thank you guys for flagging that. Woof. Almost blew the whole stream. Thank you for correcting me so early at the outset. And we got that fixed. All right. And so we're waiting for them to come on back. It is still on break. Let's make sure we have the scene pulled up. And that was from 11 Alive. And here is where we're at. Okay, so they're still on break. Let's pull this up into a picture-in-picture mode so we can see when they come on back. And then we'll see who else is joining us on this amazing, amazing day. And so thank you, Steph D, for that one. And we had some great donos. Let's see where my screen's at. Okay, so Steph D's in the house. What's up, Rocky Water? Says, it's a bit unfortunate that listening to a normal and rational hearing with real questions and answers in English is so rare that it brings me true joy to hear, but I'll take it. Thanks for waking early. First time I've been on time to the office all week, because it's early. Yeah, well, we're glad that you're here. It is nice to hear her just talk through the corruption without getting interrupted every 2 seconds. And obviously that is an opportunity for her to really get into the meat and potatoes, and she's doing a great job doing that. So amazing. What's up? NY says, Google autocorrect hates Fannie. And Knox says, Knox is a defense attorney in Texas on Locals, says, Counselor Merchant is looking great today. Fabulous hair and makeup. And she is absolutely rocking it. And I saw one from Knox. Knox was talking about the actual billing records. And I know, Knox, you were saying that the billing records were not looking good from your end as well. So we have Richard Jack says, top of the morning to everybody. Good morning to you, Richard Jack. Uberian is in the house as our newest supporter. We got Asaf also joining us as a new supporter. Maggie has been a membo for 1 month, says, let's go. Excited to hear Ashley testify. Yeah, it's been really good. It's been amazing. And so we're probably just getting into the good stuff. We got Twins Mamas here, says, I'm so darn excited. Is that wrong? No, not at all. You and me both. We're all here excited. It's like waking up in the morning. It's like, ooh, we got some Ashley Merchant testimony coming up. Amazing. Hey, T. Lewis is sharing the song that never ends. It just goes on and on, my friends. Says, good morning, everyone. Thanks, Rob. Love ya. Still singing the song. We said that yesterday. Still singing the song. It's still stuck in your head. So it's either going to be Supercalifragilistic, that song, or it's going to be the song that never ends. Tara R. says, has the state responded to the new filings? Actually, the state did respond. So I do have some other documents from Fannie that she submitted. She submitted a last-minute brief that is going to attempt to get Judge McAfee to not disqualify her. And Steve Sadow, Trump's attorney, already responded to this. So we'll see if we can get to that one today. But there have been new filings indeed. Guest says, can Trump sue Letitia? Personally, I don't think so. Like in her personal capacity, I don't know what that would be for. But right now, he's being prosecuted by the government, and she's got qualified immunity. And so there's, I think, little recourse other than changing out her position as, throughout an election. I don't think he's got much recourse against Letitia personally, but it's a great question. Fannie is done, says NY. Good to see you, NY. We had this one from Johnny Five, says, wasn't the statement made by Big Fannie to Bradley witness tampering? They are coming after us. You don't need to talk to them about anything about us. It might certainly be something related to that. Yeah, I don't know if that phone call alone is enough, but certainly the other phone calls from Gabe and others, I think may, you can make an argument that it amounts to that. We got Glocky says, it's funny. If Democrats wanted Trump to go away, all they had to do was leave him alone, quit persecuting him. Now they unleashed a beast, and CNN just got convicted from their Atlanta HQ, evicted. So it's obvious that the media can't survive without Trump. We had this. Sam in Texas is bringing in some new members. What's up, Sam? Thanks for doing that. In the great state of Texas is bringing The World is on Fire in. Artsy Chicks coming here. James X. We got Kathy C's coming in. And Brandon Dirt all coming in courtesy of our friend Sam in the great state of Texas. In Texas. We've got this one from Michelle P. says, Kenny S. is coming in. Rob H., Maria C., Michael G., Cool Roy's here. Nini's coming in. Pete M., Thomas, and Dooms is here, courtesy of Michelle P. Thank you, Michelle. Very, very nice. Thank you for sending those in. T. Ree is here. Thank you, T. Ree, for sending that nice dono in. Andrew the Bard is bringing in 5 membos. Dark M. We got Max S. TC's coming in. Get Sick Rich. We got Savage Cashew. Whew, sounds brutal. All in the house, courtesy of Andrew the Bard. Thank you, Andrew, for bringing in 5 new membos. We got NY says, you know, that money that Nathan Wade got paid was from asset forfeiture from Atlanta Airport. Yeah, so Nathan Wade got paid with a bunch of seized criminal money, evidently, is how that works. We got Glocky is saying that Zuckerberg says, better not be in here spreading truth. T. Lewis says, there is no doubt that Willis and Wade are watching this. What are the odds that McAfee is watching it as well? Good question. Glocky says, all these people either covering for Fannie or just innocent people caught up in her fraud in the DA's office can't be liking the fact that their names are getting thrown around in public. I wonder if any of them will quit or flip. Margaret K. says, good morning, Robert. Half for your dear brother, too. Oh, my brother Jojo? That's great. I just ordered him a new 5 for Fighting. He wanted a new 5 for Fighting CD. So that will help defray those costs. Thank you for that, Margaret. Great channel, news and legal analysis without mindless chatter. Thank you, Margaret. Really great to have you. Thanks for being here and sending in a super chat on this beautiful morning. Craig is over on Rumble. Says next on the chopping block is Bond, Dexter Bond, LOL. Yeah, he's in hot water now because he's the rubber stamp for Fannie Willis. Okay, here's the one from Knox. Knox is a defense attorney in Texas. She says, I am a complex felony contract attorney. I make 125 hours daily, and I bill down to 10 minutes. So there you go, right? Nathan.
All right, shout out to Robert Cavea, man. Shout out to him, man, for helping us with this stream here. We got the Georgia Senate and Ashley Merchant looking into the finances. So like I said before, this is going to be many. Hold on. Shit. Did I get my settings right? Hold on. Audio. Turtle Beach. Yep. Okay. So, okay. I just had to test the, so this is going to be many entities. So this is the Georgia Senate. They're going to have I believe tomorrow they're going to have a Fulton County Commission. So they're going to have a hearing. So you got the Georgia Senate, you got the Georgia Fulton County, but then you're going to have the county commission. So I'm betting IRS is going to want to hear about this. And as you know, the committee council up in DC, they're going to want to hear. They're going to want to hear some stuff from the one who got fired from Fannie Willis's Tanisha. Was it Tanisha? The whistleblower. So yeah, we got. I mean, this thing is like I said, these entities outside of the whole Trump case is what Fannie and Wade got to worry about. The Trump case, they're just going to get just disqualified from that. The real pain comes, like I said, with the Senate, with the House Judiciary, possibly IRS, the Fulton County Commission, and it's another entity. Let's see, you got Georgia Senate, Fulton County Commission, you got The House Judiciary. Oh, and the ethics. Yeah, the ethics. Yeah, now the ethics board is the one that can take her license. So yeah, a long road to pain, y'all. Long road to pain. So, yeah, man, it's woo not looking good for the Fani Willis. It's not looking good at all, y'all. Not looking good one bit. So, um, man, shout out to Tim, shout out to Twin, shout out to Deacon, man, shout out to y'all for coming out, man. I know I did this early in the morning. I know. But hey, got to get these hearings done. Oh, by the way, as y'all know, what's her name? Nikki Haley. Nikki Haley, money finally dried up, so she done stepped down. The funders, they finally pulled the money on her. They're like, look, we can't keep funding you. You got washed in the, what was that? She got washed in the, oh gosh. She got washed in the primary last night. She won Vermont. So Vermont is the only state that she won. And yeah. Yeah, she lost that badly. So yeah, Vermont, she won that. So she's she won DC and she won Vermont. So she won two little pockets. One DC being a pocket and Vermont being a pocket. She won two pockets and pockets full of Democrats, I might add. So she has finally stepped down. They're saying that she's not going to endorse Trump. I mean, damn. Okay, Nikki. So yeah, she's very sour, very, very sour, very bitter, I guess. It is what it is. Nikki Haley doesn't want to, but like I think Gavin Newsom said, she's a surrogate for the Democrats. So yeah, why would she endorse Trump when she's a surrogate for the Democratic Party? Wouldn't make sense. Of course, she would do the bidding of the Democrats. She was funded by the Democrats, and so yeah, she's a surrogate of the Democrats. So the Democrats voted for her. So yeah, I don't see why she just don't become a Democrat. But we know all the story to that. So yeah, shout out. Are we getting back to the? Okay, let's see what Robert Cabell is talking about. So I'm gonna let him explain on some things here. Look like they got the paperwork for they're tying this to the White House. So, oh, Jim Jordan and them are watching this. So yeah, this is gonna be good, you guys. This is gonna be really good, really, really, really good. So let me let Robert take back over the stream, and oh yeah, the back in session. Okay, y'all, let me get back to the thing. Okay, hold on. Whoop, 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 whoop.
Explained it was November 5th is when the work was concluded. And so he had done that work up until then.
Yeah, right.
And that he only billed when it was concluded. So he said that the 24 hours, who knows when it spanned, but that how he billed was
Would have had to be
concluded.
between November 3rd and November 5th, though, right? So it had to be on the 4th and the 5th, 12 hours a day?
It had to
At
be.
least.
And, the other thing that I noticed with this is prepared cases for pretrial. At this point, it says anti-corruption unit. His two law partners are the conflict lawyers for the anti-corruption unit. So you've got it's like my husband couldn't represent someone who's adverse to me. Like my husband is my law partner. He can't be doing privilege review on a case I'm prosecuting.
Yeah.
So he's consulting on anti-corruption cases for the DA's office where his two law partners are doing the privilege review at the same time.
Totally.
That's one, that plus the 24 hours are the
Totally
two things that really
conflicted.
struck out to me.
Totally.
So, but the only role he had was this prosecution of this election fraud.
Yes.
Okay.
Yes, the only role.
Okay. So when it says anti-corruption, that's the corruption. We're looking at election interference.
Yes, he's never worked on any other case.
All right. Let's see that other bill there, Senator Dolezal. All right, so here's another one, if you can see that okay. This is the one we put up earlier. It looks to be much more specific date-wise anyway than just, those 24-hour chunks like that. Okay.
Right. I mean, it's more specific, but it doesn't say what, like
Team
Just for
meeting,
example, team
argument
meeting and
prep.
argument prep.
There you go.
Argument prep for what? I mean, normally when we do bills,
Whatever.
we would say,
Phone call
argue
with
motion
Fannie
to
later.
dismiss or argue whatever the motion is. Research, what are you researching?
She wants to go to
Researching
Cancun, and
statutory
I don't wanna
privilege.
go.
Whatever it is.
And this
something-
one, he shows date ranges when it's over multiple days. Like down at the bottom, 426 to 427, 18 hours.
Right.
If I'm reading that right, or 16 hours. But on that previous one, he just
He
has
didn't do
one
that.
day, 24 hours.
Yes.
Okay.
And how
you
he-
say these are approved by Fonnie Willis. By contract, she has to approve these billings.
Yes, she does. And those are approved by her. So if there were any questions, and as a lawyer, when we submit bills to clients, they regularly question, and I know when I've done appointed work, they regularly question that as well. You have to list exactly what you're in court for, exactly what you're drafting. You can't just say prepared cases. You've got to say, what did you prepare? What did you draft? So, I mean, the county, in Cobb County, for example, they make you actually attach motions. If you do like an appeal or something and you're billing for that, you have to actually attach it to prove that you did the work. I did go back at the break, though, and I have an answer to one of your questions earlier. I just wanted to clear up. You had asked me when the special purpose grand jury had convened. I looked, the state filed a response. So this is DA Willis's response that was filed on February 2nd. They wrote on
This
page...
response to your motion to disqualify?
Yes, sir.
Okay.
Response to my motion. On page 13, they wrote, shortly after his appointment in January 2022, District Attorney Willis petitioned the Chief Judge of the Superior Court to convene the Superior Court judges to consider her request for the special purpose grand jury, to conduct an investigation into the facts and circumstances relating directly or indirectly to the possible attempts to disrupt the lawful administration of the 2020 elections of the state of Georgia. And they attached that exhibit. So you had asked me earlier when she petitioned. So it was, in their own words, shortly after his appointment.
Okay. So this whole, the cases are about attempts to disrupt, because obviously Georgia certified Biden as the winner, and he got inaugurated, that following January, and this is years later we're having this whole investigation.
Yes, attempts. And my client specifically is charged with attempt and conspiracy. So he's not charged with actually doing a specific act. He's charged with conspiring or attempt, depending on which section you're talking about in the charges.
Some of these itemized statements show drafting.
Yes.
Did Mr. Wade draft any documents to your knowledge, or
No.
prepare any legal documents at all?
No, not that I'm aware of. And that
Did
would
he
be...
sign any pleadings as if he was the drafting attorney?
No, and he's not the one that usually files them. Will Wooten is the one that usually does the filing. There's two other prosecutors that also do it. Alex, and I don't want to butcher his last name, starts with a B, but he does it, and then Grant Rude. Anna Cross has also filed pleadings, but not Mr. Wade.
In your review of all of his billings, did you ever see where any of his time or bills were cut or reduced by whoever was reviewing them and approving them, either Ms. Willis or her deputy?
No, I never saw any questions. And her response, or their office's response, doesn't indicate that was ever done either.
And your experience when you were doing like your public defender work, that you were reviewed and they cut your time?
Oh my gosh, yes. Yeah, when I first left the public defender, I had a couple clients that were in the appeal process, because at that point I was in the appeals division when I left, and I didn't want their cases to linger, and I didn't want a new lawyer to have to kind of just pick up right when they were going to the appellate courts. So I kept some of them. Some of them the judges appointed me, and so I would be paid, I think it was $50 an hour, $45 an hour, something like that. And then some I just took pro bono, but I had to get those bills approved. I mean, they were regularly cut.
On Mr. Wade's contract, he was allowed to bill, he was capped, he could not bill more than $35,000 in any given month.
And he hit it.
And that was not, so the original contract
Every month.
before the special purpose
Make
grand
sure you
jury
hit that
was
35.
started was a lower cap. This was the cap for the majority of his work during the special purpose grand jury and then now. So he had a contract November 1st, 2021 up until October 31st, 2021. And the cap was lower for that. Then there was a period of, I think it's 15 or 16 days where he did not have a contract. Which also happened to be one of the times they were out of town. But so they re-upped the contract November 15th, and then it had a cap. But the cap was significantly higher. I mean, I don't remember the first cap. But it was not $35,000.
Here's a document you produced. I think you prepared this summary that shows all the payments that he received.
Ooh, look at
Either I
this.
did this or this might have come from Fulton County Purchasing.
All right.
Okay.
So that was produced to you from Fulton County as
Yes.
all the payments he received?
Yes, this was produced from Fulton County.
Look at that,
yes.
33
And
grand,
what's the
34
total? Is that
grand.
just my eyes aren't
35
so
grand,
good.
20
What,
grand, 36
that
grand.
looks like 22 all the way through 23.
Yes, 22 through 23. So, and so his first bill would have been paid in January of 2022. So he
15
billed for time
grand.
in November, December. And then you see those two bills. And so those were $15,000. I believe that was the cap. So in January, he was
Always hit
paid for
that cap.
$15,000 for work in November. And then in December, he had work totaling $15,000. And he was paid for both of those in January.
That's why there's those top two invoices for 15,000.
Yes, that's why there's those top two invoices. And they produced some other documents to me as well that showed which funds they came out of. So I was able to track which ones came from state seizure money and then which ones came from county general fund.
And that was all before this grand jury was even approved.
The grand jury was not approved until June of 2022.
Okay, it was requested in January.
It was, and I just looked that up at the break. So it was requested in January. It was approved in June. The order, actually. But what happened was they started picking, so it looks like they started picking the grand jurors on May 2nd of 2022, and they actually started hearing evidence June 1st of 2022.
Okay, so lots of this time was way before he would have been having to question any witnesses or
Billing.
attend grand jury hearings or anything.
Yes, he could not have attended a grand jury hearing until at the earliest May 2nd.
You were talking about the experience and expertise of the three outside, I'm gonna call them outside counsel, because they were not direct employees of the DA's office.
Correct.
Had Mr. Wade ever tried a felony case, prosecuted a felony case before this, to your knowledge?
No, that he has never prosecuted a felony case. And I asked his law partner that, who had been his law partner for some time, that he had never prosecuted that. I also did some independent research in the metro areas where I knew that he had worked in Cobb County, so I looked to see if he had ever been filed as a prosecutor in Cobb County for felonies, and he was actually just a solicitor, and solicitors is, because you'd said not everybody may understand the difference between solicitors and
We've
district
got an
attorneys.
ex-solicitor on this panel, so don't say anything negative about them.
So he can tell you all about it.
They
But
prosecute
they
misdemeanors
pro-
only, right?
Yes, and in
Yeah.
Cobb County specifically, they prosecute misdemeanors, yes.
Okay.
Interesting, okay.
It looks like he's pretty much hitting the maximum that he was allowed to under his contract?
Every time.
Yes, most months he did.
Hit the cap.
And this is through that block billing that was not specifically itemized exactly what he was doing or how much time on each task?
Always block billed. He never itemized bills, never was specific.
He
What
did
were
say
the
he had more
caps
details
for
on
the
some of
other
those.
two special counsel? Were they also limited? I assume you've received their contracts, or did they have a written contract?
They did, so they had written contracts, and I do have those, and they did have caps. They were significantly lower than Mr. Wade's. They do not currently have contracts, and I just found that out at a hearing because we had asked for that. We had asked for it in open records, and then I had subpoenaed it as well. Pretty much every subpoena I filed for the hearing, the state filed a motion to quash, including this one.
Of course.
And Ms. Cross was at the hearing, and she said, I can just tell you right now I don't have a contract. So I had thought, I was under the impression that they just weren't giving me that contract. I had no idea that they just didn't
Wow,
have
interesting.
one. So apparently right now, Mr. Floyd and Ms. Cross don't have contracts.
Do you
wild.
think that was intentional so that they don't have to disclose how much they're earning?
I think it was sloppy.
Okay. Does Mr. Wade have a current contract?
Yes, he does. I also think it may have been, I don't know if it's disclosure, but I can tell you that they've changed, since I started looking at this, they've changed what they put on the public documents. I used to be able to go to Open Checkbook and see every time he would get a check, and since I filed this, none of them have come up. So I
Amazing.
don't know if he's not being paid anymore.
They're so corrupt.
Or if he hasn't filed any invoices, but the invoices are due, I believe, 30 days after.
So
So,
corrupt.
they regularly came up, but now all of a sudden they don't.
Okay.
Yeah. You start digging around, all the transparency evaporates all of a sudden.
So eventually
From
you
Fannie.
sought to disqualify Ms. Willis from serving as counsel and prosecuting Mr. Roman's case.
I did.
Okay. Can you pull up that motion? That motion was filed here in January, I think it was January 8th of 2024.
Yes.
What was your motion to disqualify based on?
It was based on a number of things, but it was based on mostly the fact that Miss Willis and Mr. Wade had a romantic relationship and they had been traveling and he had been paying for a lot of that travel. So there were a couple different things. She had not followed the statute. So the statute I referenced earlier, 15-18-20, said that you had to have county approval. She didn't have that. So that was one thing. There were also.
You had figured that out through your financial records?
Yes, I had figured that out through my financial records, through open records, through reviewing all the Board of County Commissioners. And I actually, to that motion, I attached, just on this issue, I actually attached a document showing how independent special counsel would normally be appointed, or I'm sorry, special counsel, because I found one where, and I think it's exhibit, let's see. It's exhibit J. I found one where Fulton County had actually been asked to approve a line item for an independent contractor agreement. And so this, I used it as an example of what normally would happen.
Was that for an attorney?
It was for an attorney.
So she's saying in pleadings now that she's not required to get county approval, but in the past, for people other than Wade, she had gotten approval?
This is actually the county attorney. So
Okay.
this document is the county attorney. I do not believe she's ever gotten approval for anybody. And her filing said she's doesn't. I mean, her filing, I at the break, I was looking at it. I mean, she said that that I incorrectly contend that the appointment exercised by, and in, parentheses, a state constitutional officer must be followed by an approval of the local government's Board of Commissioners. And, she says over and over again that I'm just wrong, that she doesn't have to because she's a state constitutional officer. So that was their position, that she doesn't have to.
So is that one of the grounds for your motion to disqualify these, let's just call them financial irregularities, that she had not complied with the state law or county policy of getting prior approval?
Yes, that was one of the primary bases. But then I also reviewed case law and saw, the conflict of interest. And, our motion, the theory, basically just to sum up the motion, is that essentially he's getting paid all of this money and they're not going through the proper procedures. And I go through it in the motion. I talk about how he didn't file an oath, which is rare. I'm one of those.
Didn't follow what?
He didn't file an oath of office. And I'm one of those people that I always, when I first start a case, I always make sure that everything is all the I's are dotted and the T's are crossed. So I always pull that. Anytime I've only ever had special counsel twice, and it's been people who were not paid, who were district attorneys in other jurisdictions who took the case on, which is the normal process in the state. But I've always pulled that just to see that they're sworn. That's something that's important to me. And I couldn't find it, so I did open records to the probate court, to the Superior Court, and there was no oath of office filed.
Sworn for the special assistant district attorney?
Yes, if you're going to be inside of a grand juries are highly regulated. I can't just go in a grand jury. None of us can just go into a grand jury. So you have to be a sworn officer of the state to actually be in there, particularly to present evidence. And so I wanted to see if he had taken an oath. And that's something that, you would file. It should be publicly available, not something that's really, highly contentious or secret, and there wasn't one. So, once I learned that, I was like, why are they not filing an oath? This is odd. There's no public approval of these contracts. There's no oath of office filed. This is different, what's going on. We later found out that he had taken an oath, but nobody had filed it, and the law requires, there's a statute that requires you actually file it.
I have looked at that. So the statute for a district attorney,
I'm going to try to
their
fix the
oath
audio
when they are
sync
sworn in that
problem.
position says, I do swear that I will faithfully and impartially and without fear, favor, or affection discharge my duties as district attorney and will only take my lawful compensation.
Yes.
So help me God. Did Ms. Willis sign her oath that swore she would not take any unlawful compensation?
Yes, she did that, and then she also filed some disclosure forms that are required. There's financial disclosure forms that Fulton County requires that you file every year, and you have to disclose if you've received any gift over $100. So from anybody doing business with the county. And Fulton County is I used to be a Fulton County employee. They are very strict on those types of things. So anytime there's anything that could be construed as a gift over $100, and I've gone to lunch with prosecutors before who wouldn't let me pay for lunch because they're like, what if it's over $100, So people do take that pretty seriously.
So that would apply to Ms. Willis would not be allowed to receive gifts from whom?
From anybody who was, and I actually believe I attached it as an exhibit. It's basically anybody who is doing business or seeking to do business with Fulton County. So, and you know, it's one of
That would
those.
include Mr. Wade, obviously, then?
Oh, definitely.
Okay.
And that's, you know, that makes sense because that's one of those provisions that's supposed to, you know, be guarding against honest services.
Like anti-kickback statute.
It's exactly what
Hire
it's based on.
somebody as a vendor and they give you gifts in exchange.
Yes. And so they require that you disclose that every year. It's signed under oath. You have to file it with Fulton County.
So how'd you learn about this relationship between Mr. Wade? I think this has been acknowledged now by both parties, correct?
It has, yes.
It's a dispute as to when it began, but it's acknowledged that they had I don't know if they still do, but at least had a romantic relationship.
Yes,
said
that's
How'd
enough.
you figure that out? How'd you
2022.
find out?
So at first, I knew Mr. Wade and I knew Miss Willis, and a lot of people in the community were a little surprised to see Nathan, Mr. Wade handling this case. It was just, a lot of people said that, and so a lot of people were talking about that, and it was kind of surprising because it's not really, you know, he does a lot of law practice, but this isn't what you would imagine him doing.
Did you ever see him
Everyone
have
knew in
other
the
billings?
community.
How do you
It's a
have
small
time to represent
community.
anybody else when he's billing, 24 hours a day to Fulton County?
He had other people working for him. Like he had a law student working for him for a while, and then he had a first-year associate. So I'm assuming that they would probably do whatever other work he had.
Did you ever look at his calendar? Did you have access to that to see if
No.
it matched up?
No, I didn't have access to his calendar, and I didn't have access to their like text messages. I mean, I was able to get get his geolocation data through subpoena, but the one thing that really struck me is if I was accused of something and I was saying I didn't do it, I would download my phone. They have a system. It's called Celebrate, and Fulton County pays for it. City of Atlanta pays for it. It's literally a system that you can hook your phone into. I have an investigator that has it, and I have my clients do it all the time. You hook your phone up, and it can find deleted text. It can find everything, and you can limit it. You can say I only want text with this person. So if I was being accused of having an affair with someone, and I said it didn't start until April, and someone else said it started in October, the easiest thing to do is to, download that phone. And for privacy concerns, you can file it under seal, but you could easily narrow it down and say, I want this timeline. I want all of our texts from, November 2021, and it would easily tell whether or not they were romantic in nature.
Before I leave the billing issues, did you ever compare Floyd and Cross's bills to Wade's to see if they were meeting together, like there was that meeting with teams or what? Were they billing for the same meetings as well?
So I looked at that. One thing is we don't have most of Floyd's. So Floyd has not billed in quite some time. So I didn't have his to compare, but I did look at Anna Cross's. The one day that I remember looking at was when they were in federal court to see, because so Ms. Cross was the one actually litigating in federal court. But Mr. Wade was sitting there with them at council table, and they both billed for that. I wanted to see if he billed for time that he was sitting in court waiting, because I know in Cobb County, for example, with appointed work, if we're sitting in court waiting, we can't bill unless we're actually doing something. Like they won't pay for two people to sit there. And so I wanted to look at that. But they were both there in court that day.
What about the teams meeting where he billed for? Were either of them involved in that team, since they're also outside special counsel?
No, they were not. So all of those people were people who would not have itemized that.
Okay.
Employees.
All right, back to your uncovering the relationship.
Yes,
How did
yeah.
you figure it out?
So Terrence Bradley was Nathan Wade's law partner originally, and he was also his lawyer in the divorce. I did not at the time know that they had filed for divorce. I knew Nathan's wife. I knew both of them historically from Cobb County. I mean, they're, people knew them in Cobb County. Mr. Bradley actually called me after an article. We were looking into the financial irregularities. We're looking into how much money had been paid, because everybody in the case was kind of like, what, why do you have special
this
counsel?
case?
On this case, yeah. Like,
Was
why are
Bradley still a partner with Wade at that time?
He was not. There was testimony that their partnership ended in summer of 2023. So it had just ended, is my understanding. And it's, it's kind of unclear, like what month. The testimony is very unclear as to when they actually, I have when they dissolved. I think it was September, but it's very unclear as to their partnership. And I will say their partnership was a loose partnership. They had a partnership with the bar, but they all had separate legal entities. So each of them were filed as the law office of Terrence Bradley, law office of Nathan Wade. They had some joint bank accounts, but then they had some separate bank accounts. So I don't really know the exact structure. It was a very loose type of organization, but they were working together. And so Terrence actually called me. He had seen an article where I had done open records with another lawyer, Manny Aurora, and we had uncovered how much money everybody had made. The news had gotten wind of that, and I later learned that the news had open records to get all of my open records. So every time I would get something, the news would get it, because I wondered how that happened. But so that somebody published that, and I had done some more open records. And Miss Willis actually called Mr. Bradley when I did these open records and said, they're looking into us. And he called me because he was worried about it. And so we had a conversation, and he actually asked me, do I need a lawyer? What's going on? What are you investigating? What's the parameters of this? And we had a conversation, and I said, well, my interests are different than yours. I represent Mr. Roman, so I can't advise you. That would be a conflict. He asked if John, my husband, could, and I said, no, that's a conflict too. If you feel like you need somebody, you need to talk to someone else. At the time, that was early in September. I had court in Cobb County, and I ran into Mr. Bradley. I was in Judge Harris's courtroom. I think it was either September 11th or 13th. I checked my calendar a week or so ago, but it was one of those dates. And I was taking a plea in front of Judge Harris, and Mr. Bradley was also there. Another lawyer who ultimately represented Mr. Bradley at our hearing, B.C. Chopra, he was there in court also. And then a friend of all of ours, who's a district attorney, his name is Burt Cohen. He was taking a plea with me. And Burt and I have known each other for a long time. Terrence, BC, everybody's known each other for a long time. We were all sitting in a conference room attached to that courtroom, waiting for the pleas, chit-chatting, took the plea, went back in, and Mr. Bradley essentially went through the whole thing and said, well, this is what's really happening. I had a notepad, and I took notes on all the things to ask for open records.
So what did he say was really happening when he said this is what's happening?
He said that they met at a judicial conference before. He was very specific that it was before she became DA, because that was one of the things that he couldn't remember when the judicial conference was, but he knew that it was before she became DA.
When did she become DA?
She became DA in it would have been January 2021.
Okay.
So she became DA January 1st, 2021, but she had a transition team leading up to that. So, and Mr. Wade was in charge of her transition team. So Mr. Bradley told me all of that. We met for about an hour. Said that they had been together. They met at this conference. Nathan was still married, and Mr. Bradley was upset because of what happened in the divorce. He was upset because they were still married, the Wades were still married, and he essentially just left her after meeting Miss Willis and dropping the kids off at college.
And Bradley was Wade's attorney in that divorce action you're talking about?
He claims he was.
Okay.
Yes, I didn't know that at the time.
But they were law partners.
They had been,
Okay.
yes.
Okay.
And I actually don't know if he was still
document.
his attorney when he talked to me. I don't know if he was or not.
All right.
Because at some point, Mr. Wade represented himself, and then he hired a different lawyer. So I didn't know anything about the divorce at that time.
So Bradley did not like the way Wade had treated his wife,
He did not.
but he
did not-
represented him.
He did not like the
Okay.
way he had treated his wife. He didn't like what was happening in the divorce
Jocelyn,
proceeding, yes.
innocent party and
And
all
I mean,
this.
I remember specifically him
Fanny
saying,
wrecked their
I
home.
handle my business, things like that. Like, that I don't leave my wife without alimony. Because this, and we talked about it. I mean, Miss Wade had been a stay-at-home mom for, they'd been married almost 30 years. And
Yep,
literally
totally
it was
screwed.
right after they dropped their youngest off at college that he said,
I'm out.
Move out,
And he got the contract.
And so
Sick.
we went through, I was obviously interested in, wait, what's happening? Walk me through this. And so he was telling me about the access cards, that Mr. Wade had access cards, telling me about the contracts, told me about their contract, that they had that Nathan had brought them the contract for the first appearance hearings. They had a contract for that. We didn't talk about that yet. That they had the contract for the taint work, and then ultimately that Nathan was hired as the attorney on this case. That they had been dating before, and he told me, they met at hotels. He would go to her place. I remember him saying, you need to find her, her bestie who they had a falling out. That's the person whose condo it was that they would meet at. And
And did you later determine who that bestie was?
yes, it was Robin Yeardy. It was not until sometime later
Another
that I
witness we
determined that.
heard from.
It was very difficult to determine who that was because he did not remember her name. And
But he knew her by sight.
he did.
Did he later confirm to you or identify who she was?
Yes. So I had sent him a couple pictures or showed him a couple pictures of some other folks or
This
names.
was in January of 24, right
Yes.
before your motion?
It
Okay.
was. It may have even been after I filed the motion. It was around the time, it was either before or around the time, but it was in January. I had gotten some open records requests from the DA's office. They had a contract. Yep.
We just put on the screen
There it is,
some of the
perfect.
text messages that you produced to us.
Yes.
This is
yes.
from your phone,
It is. And
and
so
you're
the,
talking to Terrence Bradley, I see over there on the left.
yes. And so when you see on the 14th, that one that's right in the middle that says file attachment with MIME type, that
Yes.
is a picture of her. So it doesn't show up on this, but it's actually, there's a picture of
So
Miss
while
Yeardy.
you're texting, you're shooting him a picture to see if he can identify Robin Yeardy.
Yes, yes.
Did
And-
he identify her?
He did, yes. He said, yes, that's her, that's the East Point. And he thought the apartment was in East Point. I later found out it was
That's
in
her,
Hapeville,
Robin.
but those are very
Right.
close in, close
So
areas.
he knew they would meet at that apartment?
He did, yes. He knew all
Okay.
about it. And it was hard to find Miss Yeardy. What happened, and she was Robin Bryant, and then she got married and was Yeardy. I did an open records request for a contract that the DA's office got. It's called Critical Mention. They, she has I guess he's an attorney, but he's sort of in charge of communications. His name is Jeff DeSantis. Right after Ms. Willis had opened the investigation in this case, that same week.
That's the White House guy.
He contracted a company called Critical Mention, which is a media monitoring company.
Yep.
They put a dollar figure basically on your media
DeSantis.
presence, and they give you these analytical reports. And they say, hey, you did great on MSNBC. That's $1 million worth of, stuff for your brand. The Fonnie Willis brand is doing well, or this phrase is doing well, things like that.
She had an employee in her office that was responsible for promoting her image, her publicity.
She had a publicly funded contract for this. So Jeff DeSantis contracted or called this company, and it's in the emails. I think I provided those as well, but contacted Critical Mention and said, we need to hire you to do media monitoring. And it was the same week that she had sent the letter to Raffensperger and Kemp about this case. Said, we need to have a contract to do media monitoring. Got $10,000 approved, paid $10,000 for a year contract for an annual contract.
Who approved that?
Jeff DeSantis's email said the county approved it, and his emails indicated that it was hard to get approved, that he had to really push, I think is what he said. There's some language to that, but the county paid for it.
Do other DAs do that?
I'd never even heard of media monitoring. I didn't even know it
Yeah.
existed. No. It was very shocking. But so I got some of the emails about this media monitoring. So I did open records, and again, once I got them, they shut me down and wouldn't give me anything else. But so these emails have attachments, they're PDFs, and you can see in the emails the hyperlink to them where you can actually see the analytical reports. That's what I wanted to get, and obviously nobody would give those to me. But these emails showed a trail where two people in her office, so Miss Willis, Mr. DeSantis, and then Robin Yeardy, were the ones that had access to this Critical
Media.
Mention profile. It's it's a platform that you can log into and see, how am I doing in the media.
What was Robin Yeardy's role in the DA's office?
She was a liaison between the news organizations. So she said that when CNN, MSNBC wanted her on, they would call Robin and she would coordinate it. She would do her hair and makeup, and then she would coordinate her interviews. But so how I found Robin was I'm going through these emails, and all of a sudden I see an email from Mr. DeSantis saying, take Robin off of this account. She's no longer with the office. And I was like, oh, I wonder if that's her. And so I found a picture of her and I asked Terrence, is that her? Because I found out she had been fired or had been let go or had quit or whatever it was. And so that's how I was able to figure out who Robin Yeardy was. Then we were able to run her, run her information, get an address. And that's how we were able to narrow down where this Hapeville condo was.
Okay, so that's where basically Miss Willis and Mr. Wade would meet
Yes.
for their relationship.
Yes, yes.
Yeah.
But Mr. Bradley told me at that first meeting that they would meet at hotels. He told me about a lot of travel. I mean, he detailed, he detailed a lot of stuff. He said that they traveled to Texas, they traveled to Florida,
Napa, Belize.
just, a lot of different travel. He said Belize,
Miami.
he specifically said Belize, a cruise, the Bahamas, things like that.
And you were later able to verify that through other subpoenas or open records request or whatever?
Yes, I was. I was able to, I subpoenaed bank records, I
then
subpoenaed
he
credit card
forgot it
records.
all.
And then I actually subpoenaed
Very
the travel
convenient.
agencies that Mr. Wade used for some of those trips. He used, two of the cruises that they took, he used a travel agency. So there was a cruise to the Bahamas, I got through a travel agency. There was a trip to Aruba that I got through the travel agency. And then there was another cruise, I think that one was to the Bahamas also, that I got through a different travel agency. And then his credit cards are the ones that showed all the Belize trips.
And they showed that he was buying the tickets for both himself and Miss Willis?
Oh, yes, the credit
Yeah.
card statements. So because I guess he used a travel agency, his credit card statements actually had her name and seat number and all that on it.
Okay. and
So, I
they-
mean, there was no disputing.
Clear it was paid for by him on his credit cards?
Yes. Oh, yes.
All right, is
crystal
this
clear.
the document you gave us from the Capital One there?
It is, yes. And there you can see, so Clara Bowman is Mr. Wade's mom. So this trip, this was the cruise that happened October
Mom right there.
31st, around that date. Mr. Wade paid for Miss Willis, Mr.
Nathan
Wade,
Wade
and then
right
his
there.
mother's plane tickets, and then
Willis
also
right there.
their cruise receipt. I think that one
Fanny.
was Royal Caribbean.
Okay. So your summary here showing the trips, we know that in late October, they took a cruise to the Bahamas, and this is from his financial records. He paid for this for both tickets?
Yes, this is from his financial records, and I tried to be, there were a lot of Ubers and things like that. I did not include things like that,
Okay.
that I wasn't positive. I wanted to be under-inclusive, not over-inclusive.
And then you show the trip to Aruba, another one to Bahamas, one to Belize, one to Napa Valley, California. These are all from October 22 up till May of 23.
Yes,
Okay. This is a document you produced us?
Yes.
This summary, is this something we prepared?
no, it's a summary.
Okay. And so you discovered that and verified its accuracy through these credit card receipts, et cetera?
Yes. Oh, yes.
Okay. Do either of them deny these trips occurred?
No, not at all.
So is this the impropriety, the financial impropriety of getting financial benefit from the job that he's paying for her way on these trips with money
Yes.
that she's paying him and approving?
This is the, what I would call undisputed, some of the other stuff on his credit cards, it looks like there's trips to Charlotte and Florida and other things like that. But this is what we could undisputed say was with Miss Willis.
All right, I'm going to switch this a little bit here, see if we can get a better sync.
So back to you're a good investigative reporter here. So you have heard these rumors, and now Mr. Bradley, just by almost happenstance, you're with him in court. And spills the beans on it and verifies it, and you go get the documents to prove it's accurate.
Yes.
And you identify
still hear that?
year to get him to say, yeah, that's the woman whose
Hopefully you can still hear
condominium they would go to?
Yes.
Okay.
And I developed it, you joke about my investigative skills. I've done public defense most of my career, at some point or another, or pro bono. It's hard to get money for investigators, so I've learned how to do a lot of it on my own. I dig a lot on things. So, and I do like to use the Open Records Act, so I would do that and get a lot of information. But what I did was I compiled all of the information Mr. Bradley gave me, and then I did various open records requests based on it. And then, once I would get something, I would reach out to him to verify, because I wanted to make sure that I wasn't tracking anything that was wrong. I didn't want to make any allegations that didn't have support. So I would regularly verify with him. And I'd see him in court. We talked on the phone several times. I wasn't the only person that he told about this. There was another attorney on the case, Manny Aurora, who his client ultimately pled out. So he didn't continue this investigation, but he was involved in the investigation early on. And Mr. Bradley told him some of the same things that he told me. So, I was able to independently verify a lot of things, which to me, investigating is important. That the East Point location, that it was in Hateville. You know, Robin Yeardy actually did quit. You know, Mr. Bradley had told
Was
me
she
about
forced to quit, or how'd that come about?
no,
you know?
I don't believe she was forced to quit. That was a point of contention in our hearing. She said she left, that she was sent to another division. It's my understanding she had some, she was outspoken about, she didn't like some of the things that was happening in that office. And when she voiced that, she was sent to a different department to work, and it wasn't something that she wanted to do because she did the communications. And so she quit after that, is my understanding.
Okay.
Based on her testimony and, you know, the allegations and all the pleadings.
All right, so after, I might be skipping parts of your investigation because it's pretty darn thorough, and you had gotten this Trackhawk, or Cellhawk, what's it called, where you were tracking the
Yes.
location? You were mentioning to me earlier when I kind of got you off that employees can have it on their own phone if they want to, and they can, she could have gone back and proven that they had not been communicating
Yeah,
before he
just
was
the same
hired.
software.
So let me explain that, because there's two different systems, and, you know, I'm always learning new things about this, but cell phone data is one of the new things in criminal defense. We see it in a lot of cases. The Cellhawk data that you just showed, that is geolocation data. That is different from the Cellbrite. So there's two different programs. Cellhawk is the program that does geolocation data. Essentially what you do is you get all of the pings. So every time your phone, you know, you see those cell phone towers everywhere. Every time you use your phone, it's trying to find the closest tower. So in a metro area like this, there's a lot of towers. That's why we get good signals. So when he's in Hateville, there's a lot of towers. So we can really, really narrow it down. So what we had our investigator do, and I'm only talking about the geolocation stuff, I'll talk about the text in a minute, but what we had our investigator do was narrow it down. We got all the raw data, and we had him narrow down, and we actually excluded a ton of things that were not right on top of this location. Like, we wanted to be very, very careful just to have what was literally right on top of this location. So he created a geolocation fence, which,
The location you're talking about is Miss Yeardy's condo?
yes,
Okay.
it is Miss Yeardy's condo, that area. So he was able to find, essentially, just to summarize a couple of the things, where he, you know, Mr. Wade would call Miss Willis at midnight, something like that. And then all of a sudden his phone would travel, and you can actually watch it. When you do the live Cellhawk, the app,
Amazing.
it's pretty cool. You can actually watch the phone travel, and it's pinging
Follow
because
the
you're using
booty
it.
call.
You know, if you have an app open,
Yeah.
your phone's pinging. So my phone's pinging right now because I'm sure I have an app open. So it's pinging from his house all the way down to the condo at midnight, 1 a.m. And he calls her when he gets there. And then it goes silent for 4 or 5 hours. And then, you know, early in the morning hours, he starts pinging again, driving back, and then he texts her when he gets home. So,
And this is
Yeah,
before
I'm
he
safe,
gets hired in
sweetheart, love ya.
November of '21?
yes.
Okay.
So, and there's a couple different ones, and I would defer to the experts on the Cellhawk data, but that's the summaries based on what we had him do. And again, we tried to be very, very narrow. There were a lot of dates that it looked like it had happened also, but, you know, maybe he was bouncing off a different location, and so we wanted to be very narrow.
So is that why y'all asked him in the hearing, how many times had you been to this I mean, you already kind of had the date on him?
Well, so that's an interesting point. All we have as defense lawyers is the right to subpoena evidence. I have to have an evidentiary hearing to do that. I could not issue a subpoena for AT&T for this evidence until I had a hearing date. So, and it takes a while to get this stuff. We got it that morning. So, you know, the morning of the hearing, and obviously I'm kind of busy doing the hearing, we got that data. My paralegal was literally trying to download it for the investigator at the time and get it over. We knew we had the data, but we didn't know what it showed. So at that time, we didn't know, what it showed really until he was able to do the analysis. We had some preliminary reports from him, but nothing. I mean, it took a lot of hours. It's a lot of data. So it takes a lot of time to pinpoint this information. But the other thing that I was talking about, so this is the Cellhawk report, and heat map is just like how many times
yes.
it's pinging, you know. Heavy concentration is, you're talking a lot at this time, or you're at that location a lot. There's a lot of usage. The other thing I was talking about, just to make sure it's clear, so that's Cellhawk. Cellbrite is a different program. Cellbrite, and it's Celllebrite. Cellbrite is a program similar to Cellhawk, but it downloads
nighttime
data
calls,
in the
night
phone.
times and weekends.
So like this one is you pinging off of towers. It's geolocation.
Showing where you were.
Exactly.
At a certain time.
Cellbrite actually can get your texts, your pictures, your app usage, I mean, all of that stuff. So it's one of those things that if you want, if a defendant is threatening someone by text and they
Look at that
delete
Saturday
it,
night,
they'll
huh?
take their phone and hook it up to Cellbrite.
Hot and heavy on
Cellbrite
that
does
Saturday
it makes
night.
what's called a forensic copy of the phone, but you can also limit the data. So it's very expensive program. So not a lot of people have it. So when I have my clients use it, costs a lot of money for them to have it done, but the DA's office has it. They have the software, they pay for it. You can find that in their open checkbook. The city of Atlanta Police
She
have
could
it as
run a
well.
counter
But what you can do is
report.
you can copy cell phone. So, what I had mentioned earlier
You
is
have to have the cell phone to do that?
you do. You have to have the
So
cell phone.
what
to
did
do it.
Mr. Bradley give you all his cell phone? Or
No.
how'd you get Mr. Wade's cell phone?
So we did not get that data from Mr. Wade. So we only got the geolocation data from Mr. Wade. We cannot, I do not have the power to get the text messages. I don't have that power. I would have to have a search warrant. The state's the only one that has the power to actually get someone's text messages out of their phone. But my whole point in saying that was if I had been accused of having an affair and it didn't start, and I said it started in April and someone else said it started in November, they have the ability, I don't have the ability, they have the ability to plug that phone into the Cellbrite and print out a report
Right.
that shows all of the texts.
So Mr.
Create a
Wade
counter-report.
and Ms. Willis, had they wanted to disprove your allegations, could have just used that Cellbrite program,
writing.
and it would have shown no communications between them.
Yes, and it would have also showed the contents of the text. If the texts are romantic, if they're not romantic, if they're friendly, and they would control the data. So if there's something that was privileged, they could redact it. If there was something that, if they wanted to only limit it to we want to prove that we weren't talking romantically in November, they could
So
limit
they
it to
could have
that.
actually pulled up the text itself to say, hey, I need you to help me work on this case, or else, hey, I need you to meet me at the Love Nest.
Yes, 100%, yes. I don't have that ability. So I don't have the ability to get a search warrant and get that data. All I have the ability to do
Banghouse.
is get that geofencing.
Well, who found out about these 12,000 texts and calls and all that kind of stuff?
That is what I was able to get by subpoena. So I was able to get the geolocation data by subpoena. What I can't get is what's inside of the phone. I can't get the texts inside the phone.
The words in the text.
Exactly.
But you were able to find out that they were texting each other
Metadata.
Oh, yeah.
prior to November 1st of 21.
Yes,
How did
and-
you find that data? Is that anything you produced to us?
That is, so the CellHawk data actually analyzes that. So you can see, and we just summarized 2021. So approximately 12,000 interactions. That's voice and texts for the year of 20. And again, remember, 2021, he didn't get the contract until November of that year.
Right.
So most of 2021, he's not under contract. To over 2,000 voice calls, almost 10,000 text messages.
How did they explain that? Did you confront, we're not privy to what all came out in
Right.
evidence at the hearings that you've had. Did you get either one of them to say, that's not true, we didn't really talk 12,000 times, or?
No, what they did was they filed an affidavit saying that geolocation data is not always reliable.
Okay. Does that apply to Cellbrite data, though?
No, it doesn't. And it was ironic because I have a number of cases. I mean, almost
Yeah.
every murder case I've had in the last decade has had
They all
geolocation
use- they
data.
use it
Used
to
by the
convict their other
prosecution
clients.
against the defendant, right?
They use CellHawk data. I mean, literally, they're using this right now. So our investigator actually analyzed the same, there's a trial going on, it's called the YSL trial. There's this same data being used in that trial, and our investigator actually analyzed it for them in that case. So, I mean.
For
Wow,
them,
so
you
this
mean
guy's
for the
very
Fulton
credible.
County DA's office?
No, for the defense, looking at
defense.
that data. So the point is, they're currently using the same data in another courtroom to prosecute someone, but their defense in our case was that it's not reliable.
Okay.
Yeah,
Got it.
nice. Of course.
And did your
Because it
Cellbrite data come in?
implicates
The existence of the cell phone calls?
No, so the Cellbrite data, that would have to be voluntary on part of the DA to actually
So they
voluntarily.
could show you that to disprove your allegations?
100%.
Yeah,
Okay,
they would
didn't do
never
it?
do that.
No.
Neither Wade nor Willis?
No.
Never.
Okay. All
Because they
right, so
didn't,
you've done your investigation, you've determined you think there was a relationship that had begun before he was hired.
Yes,
And after having met with Mr. Bradley,
Mm-hmm.
you began to prepare a motion to disqualify and to dismiss the case altogether, right?
yes. I actually started the motion
Let me
in
get back on
September.
the cell phone.
and then
the,
added to
text
it.
messages. All right, and so then you somehow preserved, you had text communications with Mr. Bradley to confirm this?
Yes,
And was that because you didn't want to file a pleading that was inaccurate?
100%. I
You
mean,
wanted to verify the accuracy of what you were claiming had happened?
I did not want to say one word that had not been verified.
Because he was the source.
Yes.
He's the guy that was his law partner and his divorce attorney.
Yes.
Who probably knew as well as anybody in the state.
They had been best
Well,
friends also.
Okay. All right. And so let's pull these up, Senator Dolezal. When did you start? You kept these text messages somehow?
I did. So I actually, Mr. Bradley
I'll
uses
boost my volume
Android,
a
I
little
believe.
bit and speak up.
And so it was not easy to just download them, and I'm not the most tech savvy person. I also, there's a lot of texts that just went into things that I thought would just embarrass people and weren't relevant. So what I
Volume
did
for
was I
me, how's that? A little
screenshotted the
better?
texts that I thought were relevant. I tried to use those in court, but the prosecutor kept objecting and saying I was hiding things because I wasn't showing all of my text. So they just kept on and on for days saying I was hiding things. And I explained to them, I let them look through my phone. They scrolled through all my texts.
Who's they?
It was Adam Abadi was the prosecutor.
Okay.
So he just kept saying, that I was, where's the beginning of that text? Where's the thing after that? Where's the other part of that text? These aren't complete, rule of completeness, kept objecting. And I had just screenshotted the texts that I thought were highly relevant, but weren't slanderous, I guess. I don't even know the word, but there were some that Miss Willis's daughter had failed out, like things like that. They were just ugly. They didn't need to be admitted.
Oh, yeah, I read that. We
I
don't
had
need to
just,
go there.
so I had tried really hard to just screenshot the relevant ones, but they kept saying that I was hiding stuff and I wasn't showing the whole thing. So when they objected to my text coming in the screenshots, they said they wanted the whole text chain, and the judge ordered me to, if I was going to admit the text, to go figure out a way to download all of them. So I bought a program for $20-$30 and took 3 hours, and I was very proud of myself for finally figuring out how to do it. But I was able to make a copy of it and then redact our phone numbers. So this actually showed like when they're read, when they're
So
viewed.
what were you, all right, so up there on January 5th at 9:50 a.m. Mm-hmm. You're asking, what do you, read the question.
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
And what's his response?
His response was absolutely. It started when she left the DA's office and was judge in South Fulton. And so, these are things that he had told me, but I was getting ready to file. My filing deadline was the 8th. And as we're doing this, I'm fact checking line by line, basically.
So did you send him a copy of your proposed motion?
I did, and I actually admitted, so at the hearing that we had, I was able to admit the email where I sent him that. So I sent him a copy of the motion that weekend when I was I wanted him to review it, and then he had a text. He didn't write me back by email, but I submitted my email so that the court could see exactly when I sent it and when he responded, and then he responded that everything looked good. Because I asked, I said, I'm sending you this motion, I need you to look at it, and then he responded that everything looked good in it. He actually told me at first he wanted me to make some changes because I had not included the information about how much money he had received. I had only included the information about how much Wade had received, and I didn't know that it wasn't really highly relevant to my motion, but he was like, oh, that's going to tip them off that I'm talking to you, and he did not want anybody to know that he was talking. He was very concerned about what.
I'm going to let you just read through this chain.
What are they going to do to him?
We left off up there. Absolutely, it began before it began when she was a judge in South Fulton. When was she a judge in South Fulton?
She became a judge in August of 2019, and I did an open records. I first asked. I first did an open records and they said no. So then I subpoenaed the records for the judicial conference, the municipal court conference.
So she was a municipal court judge.
They were both municipal court judges. So I got the.
Who's both? You mean Wade was the judge at the time also?
Wade was a judge. He was actually a speaker on the panel. It was October 2019. So I found online an old agenda where he was speaking, and Terrence Bradley had told me that they met at a conference where Wade was speaking and Willis had gone. So I knew that. So and it was in person. So I could narrow it down because of COVID. I figured out when COVID happened and when, all the conferences went virtual. narrowed down my timeline. So I searched for this specific time period, which is when Bradley had told me the relationship started.
And when was that conference?
It was October 2019.
Found
So I
it.
found the agenda for that. So then I reached out to the municipal court judges CLE group and said, here's an open records request. I would like a list of attendees because I wanted to verify Ms.
Whoa.
Willis went there because I was trying to fact check. And they said no. So I subpoenaed them and me. I also subpoenaed,
Was she in attendance?
she was. I also,
Where
Yeah.
was that conference?
it was at Lake Lanier.
Okay.
I also did an open records request to the city of South Fulton because I know that they
Amazing.
have to sign off if your judge is going to go to a conference. So I did an open records request to them to make sure that they had actually sent her to that. So I verified from 2 different sources that she attended that conference, and that
Danny
matched what
went to
Mr.
the
Bradley had told me.
conference.
All right. So,
And
is that
Bradley
a part-time job, a municipal court
confirmed
job? Judge?
Yes,
Okay,
it is.
So Wade could continue practicing law and do that on the side?
Well, so
That's
she
like
was
3
a
days a
full-time, but
week.
Wade is a part-time, and Wade only did maybe once or twice a month at most.
Okay.
Because he was in the
Wow.
city of Marietta. I mean, he was
Got
just he was a fill-in judge
Yeah.
for that. That wasn't his.
Okay, so you
Primary job.
narrowed it down to that's when the relationship began. Scroll through here for us, and I can't read that green line. What's the
okay.
next, if you don't mind, just sort of
No,
read
of
us
course.
through.
It says, is this accurate? And this was again on
So
January.
you're saying, is this accurate? You're going over this brief and saying, I'm about to swear this in court. Will you verify it's accurate?
Yes.
Okay.
So at that
Another
time, I was
lawyer.
going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he corrected me and said, no, it was municipal court.
You had said magistrate court, and he said no.
Right.
Okay.
And I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12-something PM on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Chris Campbell was their partner.
Yes.
Okay.
And I did not disclose Mr. Bradley in my initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or
Fanny.
was he afraid of these people, or just didn't want
She's the
to
DA.
Multiple-
betray them, or what?
Multiple reasons. I mean, it's the district attorney in Fulton County. I didn't really want to
Yeah.
go, file something against her. It's
Totally.
not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in to be outing a friend of yours, but the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now.
Yeah.
Were you able to use
I don't
this to
recall.
impeach him and show that he
was
did know
speculation.
precisely what happened and when?
Yes, and he changed his testimony somewhat. At first, when he first testified, he testified that he had never discussed this with me. And
Then you showed his text messages where y'all discussed it.
well, at
Yeah,
that point,
dozens.
that caught me off guard. So, I didn't expect that. So then I pulled my text messages, and I had some screenshots of them just in case. And I told his lawyer, do you want to
Didn't
look at my
realize the
text
dude was going to
messages?
lie through his teeth.
And so then he later came back and testified that yes, he had.
Tad told you that?
Yes.
Okay. And did Wade testify at any of these hearings?
He did.
Did he acknowledge the relationship or not
He acknowledged the relationship. Yes.
before he was hired?
No, he did not. So before I filed the motion, nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther
Yeah,
King.
walk us through that. What
Mm-hmm.
were the grounds why is it you feel like Fonnie Willis should be disqualified from continuing this prosecution?
Yeah, and so and these are things that I alleged in my initial motion that was filed on January 8th. I outlined this. My client in particular was not part of the special purpose grand jury. They did not recommend him to be indicted. He was not a subject. He wasn't part of that. So
client's
he was
Michael
added on.
Roman.
That's interesting, because I remember hearing that the special grand jury had recommended prosecuting like 40-something people.
They had.
He
yes.
was not even in that list of 40.
He was not.
And they didn't take, or they, as in Fonnie Willis, did not take the advice of her own special grand jury as to more than half the people they wanted prosecuted.
Subsequently, there's been a book that was published that called "Find Me the Votes," that authors had exclusive access to her, and so all of her theories in how to indict people and who to indict was explored in that book. So from that, I was able to learn that she cut a lot of people. You know, and I mean, I have
Was that because they cut deals with them, immunity deals, or?
some of them were that. Some of them I just don't think she wanted to bother with. You
And
know,
then she added to the list, though, people that were not even recommended. Or
My
at least your client.
my client, yes,
Okay.
she added him.
Your
So he was
client.
one of the ones. So there were some people.
mistake on that one.
You know, and it's publicly available
She
in
would
that
take
book.
that
like
back if she could.
Senator Graham, Loeffler, those Purdue, those people.
They recommended prosecuting them?
Right, she had considered prosecuting them and taken them off the list. So there were a lot of people that had the consideration and then had been removed. And my client had not been considered, and then he was added. So to me, I was trying to figure out, you know, why would you want to expand it? You know, there's different ways you can go about prosecution.
You figure out why they add your client to the list?
No, but the my allegation and my motion is that, you know, the bigger the case is, the more money that's made. And that, you know, that made sense to me. So for me to file the motion to disqualify, obviously, we had to have some type of a basis, you know, besides all of the violations. And so expanding the litigation, because of how large it is, the judge has said we're probably going to have 3 trials, and each of them is going to take several months. Where if you just imagine, just follow me down the path, if you only indicted one person and it was narrow, you know, you could try it in a month. If you indict 19 people and, you know, 3 different essentially alleged criminal schemes, you know, like I divided it up earlier, that you now have 3 years of trial. You know, you've now gone from a month of trial to 3 years of trial. That's a lot more money. And so that, to me, was a financial
gets the
motive,
bill for all
particularly
that.
since my client was not recommended by the special purpose grand jury to be indicted.
And you had the data to show that she was financially benefiting from the continued prosecution.
Yes. And so to answer your question, you were saying, walk me through it. So January 8th, I have a deadline to file this. So I'm verifying, you know, and that's what you can see in the text. You can see heavy text with Mr. Bradley right around then to verify everything. I file it, and at that point, the world is shocked. I mean,
Tell me about it.
Because nobody had any idea. This had been
Right.
hidden. This was even hidden from her father, who she had testified she talks to
Yeah.
10 times a day. So very few people knew about this relationship. And so they very much wanted to know who knew about it. Mr. Bradley, that next weekend, you know, he gets some calls he gets a call, you know, trying to fish to see if he's the leak, is what it was couched as. He gets a call from a gentleman named Gabe Banks, who ultimately represented Chris Campbell he filed a motion to quash against Chris Campbell, who's the law partner.
Gabe Banks' wife works for the DA's office?
Yes, he does. She does.
Works for Fonnie Willis?
Yes, and I've not gotten it. I've not opened records it, but I have been told that Mr. Banks also has one of these special counsel contracts.
Wild.
Again, I have not opened records that, not part of my case.
All the people in the grift.
But so
protecting
he
Fannie.
calls Mr. Bradley, and Mr. Bradley calls me and another friend of ours. Her name's Cindy Yeager. She's a district attorney in Cobb County, and you know, he was upset. I talked to him. It was, I believe, a Saturday night. You know, and I could tell he was upset by his text. I left my kids and went and talked to him because I was worried about him. And you know, he took it as what he described to me as the first shot against the bow. You know, that they were trying to figure out if it was him, and they were trying to silence him. And
Trying
Gabe
to
didn't.
silence him?
And he said Gabe didn't say anything that threatened him. He just out of the blue called him, and he hadn't talked to him in quite some time. So
Yeah.
it was out of the norm for him to call. So Mr. Banks called and told him that was asking if he was the leak, meaning if he was my source. And Mr. Banks said that it was because he had seen a news article.
Wow.
And Mr. Bradley knew that wasn't the case, so he said, send me the news article. So he sent him some article that did not say he was the leak, and that put an end to it. But then the next day, Mr. Wade called Mr. Bradley's best friend and said to call, he didn't call Mr. Bradley directly, but told his friend to call Mr. Bradley and remind him of his privilege.
Wow.
Attorney-client privilege?
Yes.
Who's the best friend? Can you tell?
I'm not, he told me his name, and I'm not positive. I think I know who it is, but I'm not positive.
All right. So Wade calls Bradley's best friend, says, you better call Bradley, remind him he's got attorney-client privilege with me, and he better not spill the beans.
I do know the best friend works at a law firm called Beasley Allen. He told me that. He said his best
Yeah.
friend's name, and then he said he works at Beasley Allen. And he was pretty upset about it, and it was the same day of Miss Yeager's birthday, so he didn't want to call Cindy, but he was upset, so he called me, and we talked about it, and we were both pretty upset about it, because it seemed, why...
Tampering with witnesses.
It just seemed
Yeah.
like tampering,
Yeah.
and it's just, it's
cover
just an
up their
uncomfortable
affairs.
position to be in, and all of us were kind of worried how the state would react to all of this. But at that point, it's
Did
still...
he interpret that as Miss Willis trying to intimidate him from revealing this affair?
Or Mr. Wade.
Okay.
He took it as intimidation, yes.
Right.
Because what he called it as is the second shot across the bow. Those were his words. So he said first shot
Second
across
shot.
the bow was Gabe Banks, second shot across the bow was Nathan Wade calling.
Okay.
So that's how he interpreted it. But at that point, I had not disclosed him as the witness, as the primary source. So nobody knew that, and I was trying to protect him as much as possible, just because I knew he didn't want these calls, It's not something that you want. So they filed some motions to quash, and I had to
Quash what?
to quash all of the subpoenas, pretty much every subpoena that I had issued. The
So
state,
after you filed this motion to disqualify, I guess a hearing was scheduled?
yes,
And
yes,
then you started issuing subpoenas to line up your evidence?
yes.
That's
So,
when this witness tampering occurred?
Yes.
After that, to try to intimidate your witnesses from coming to court?
yes.
After the
So
filing.
let me walk through the timeline. So I filed this on the 8th. The next thing that happened was Miss Willis testified. I say testified. She spoke at a church on Martin Luther King Sunday, and was making some statements about why did they single out Mr. Wade. Didn't say
Racism.
anything about that we singled him out because he's the only one she's having an affair with. Did not agree to that. Instead said that it was racially
And
motivated.
the other two special prosecutors were white?
Yes.
But they were making significantly less money?
And they
Right.
weren't
And
sleeping
she
with
even
her.
said, to the church, she even said that I'm paying them the same rate, which is not true.
Not true.
Mr. Floyd's contract is for $150 an hour. It's never been $250 an hour. So that, my kids was listening to it and, said, come listen to this. And I listened to it and I was like, wait, that's not true. So that was one thing that she said that wasn't true. Also that it was racially motivated. She didn't say anything about, yeah, they're singling him out because he's the one I went on all these vacations with and he's the one I'm romantically involved in. Instead, she said that we were singling him out because of race. And then she said that they were all paid the same, which is not true. So I thought at that point, okay, they're not going to admit that they have this relationship. And so I'm texting with Mr. Bradley, oh my gosh, are they going to lie about this? Like,
Yep.
it's on their credit cards. Like, I don't know what's
Yeah,
going to
they
happen
did.
here. And so then in the
Unbelievable.
divorce proceedings, Ms. Willis had been subpoenaed to testify, and she actually invoked her executive privilege
Yeah, I
as the
remember
DA.
that. She wouldn't testify.
She would not testify. So
Then
then,
they settled it.
right, and then they settled it because because the judge said he was going to have to testify. So they settled it, and he did not have to testify.
And Jocelyn got
so
everything she wanted.
At that point, the judge had given us a hearing date, so I was able to issue subpoenas. So my subpoenas started going, and I filed the returns of the subpoenas, and all of a sudden, the motions to quash started coming in. Right around that time, the state filed their response where they admitted to this relationship, but they put limits on it. So so their response that they filed, I believe it was the February 2nd, I believe, February 2nd. So on February 2nd, they filed their opposition to our motion. They admit that there was a romantic relationship, but they claim that it started after he was hired and that all of the gifts and travel was roughly divided. They submit an affidavit from Mr. Wade, and they submitted a
Lies.
receipt from a credit card where she had paid for one plane ticket. So, it was a couple $100s on hers and then thousands of dollars on his. So then my subpoenas were filed, and every single one of them had a motion to quash. And they kept saying, I don't have a good faith basis. I don't have a good faith basis. Kept very harshly saying that I was making this up and nobody had told me this and it was, gossip and I was lying and I should be sanctioned.
Yeah.
So the court held a hearing on their motions to quash, and I was forced to disclose Mr. Bradley as a witness, which I did not want to do because I was worried because I knew they had called and all of these things, but I had to disclose him as a witness. And so at that point, I was still talking with Mr. Bradley fairly regularly, but that then changed.
Because he forgot everything. All
So
speculation.
you're judge to rule on your motion to disqualify.
Yes, sir.
In summation, the grounds for that are what? That this is improper for a prosecutor to have a relationship with the special prosecutor?
Yes, it is a conflict of interest.
Okay. And that's because of the financial benefits or just because
Mainly the
what?
financial benefits. There's a couple different aspects to it. We've also alleged some other misconduct because the prosecutors aren't allowed to publicly condemn an accused prior to trial. And she made a speech at a church and said this was racially motivated.
Yeah, everyone's
talked
a racist.
extensively about the clients being guilty. She testified at our hearing that our clients were guilty, that my client was, guilty of trying to, I don't even remember, subvert democracy or something. But she's made a number of public statements condemning their guilt, which is
Whatever.
not allowed.
That's inappropriate conduct for a prosecutor.
Very much so.
Yes.
And there's case law on that. There's bar rules on that. So there were a lot of public speeches that were made along the way. And, you can kind of follow them through this media monitoring company. But so she makes these, and then she got disqualified from prosecuting another person she wanted to prosecute.
For making public statements.
It was for a fundraising. She had thrown a fundraiser for his opponent, his political opponent.
Right.
So when that happened, you sort of see her press stuff dwindle a little bit. So she stopped making as many public comments. But then when this motion came about, she made the church speech, as I'd call it, where she's, calls me and, my client racist, and says, it condemns their guilt. And then she also gave interviews to this book. I don't know, the timing was just, it was just nuts. But the book came out right around the time that all this was happening, and it's called
Crazy.
Find Me the Votes. And
That came out in 2024, you're saying?
it came out a month ago, if even. And she literally let the authors of this book in when she was deciding how to prosecute this case, who to indict, who not to indict. I mean, their whole thing is that they had unfettered, behind the scenes access to her thought process and stuff.
big fanny. Yeah.
And she's talking about all of this, that they're guilty. But the big thing for the forensic misconduct is she's in the church speech, she's saying, and she does this in the book too, that God has told her to prosecute them. So the theme between these two things is that God told her to do this, and that she is doing the will of God by prosecuting our clients. And that is,
That's unethical.
in my opinion,
All right, so I'm trying to recollect what I remember reading in basically the Atlanta newspapers about all this, because this was new to the state Senate as well, because all of this began on January 8th, which was that the day we started, 8th or 10th or something?
It did, and that's-
it was the day session began, and all of a sudden these bombshell allegations
Yeah,
come out. And
lid got blown off.
I think that was the motivation for our Senate resolution forming this investigative committee to say, let's find out if this is true, independently of all you guys' legal issues or whatnot. So I remember she wouldn't testify in the divorce case.
right.
But did you subpoena her to testify in your motion to disqualify?
Yes, and she filed a motion to quash.
She refused to testify, but then she came to court and did testify.
Yes.
Okay. And in that.
As they were arguing the motion to quash.
I wonder, okay, so in that testimony.
Wild. Kool-Aid guy.
Did she deny the start date of this affair?
Yes, she said it started in early of 2022. There was some discrepancy between them, a month or two here and there, whether it started, generally it was around March. Is
You
when
remember.
Mr. Wade
So
and
what are
Mr.
the
Wade lied.
consequences for an attorney
Yeah.
to give sworn testimony that she did if you're Bradley, what is it, Yerke?
Yerty.
Yerty, your Trackhawk data, your other independent verifications are found to be truthful?
It's a crime. It's a felony. You'd lose your license.
Okay.
It's perjury.
Same for Wade.
Perjury.
And we have rules that are one of the, outside of privilege and confidentiality, we cannot suborn perjury. So
Yep.
if I have a client who tells me I did it, I can't put them on the stand to say I didn't do it.
Yeah, and they
I
did
mean,
that.
I would lose my license over that. I cannot do that.
And Yerty came to court and said, oh yeah, this started in 2019.
She saw them, she saw them together. She testified that she saw them romantically together. And,
Wow.
they were very close.
Hopefully the
And,
state bar is listening.
You had Bradley's text message that showed he confirmed that absolutely back in
Yes.
January.
Yes. And he had a lot of
Before-
details, little details that matched up.
Yeah.
Did you get other details from him by phone?
Yes.
That wasn't in the text? What did he,
A garage door opener that Mr. Wade had a garage door opener, and then I've subsequently learned that he told Mr. Aurora the same thing.
Yep.
And
Garage door opener to her place?
To her place.
Okay.
Yeah, to her place.
Yeah, don't want
And there were other
bother
things, I mean, just a lot of context, things about how freely Mr. Wade could go in and out of the office, the DA's office, stuff about that they would sometimes use hotels. One thing that he told me was that Mr. Wade had, before he filed for divorce, had used Mr. Bradley's credit card and then paid him back in cash for, so that there wouldn't be a record of it.
Okay. All right, so I'm a little puzzled by the legal standard. I'm reading the newspaper articles that explain to us the difference between a conflict of interest and an appearance of a conflict or an appearance of impropriety.
That is the big argument right now. And I'm not the best person to explain that. My husband argued that part. But, appearance of impropriety, it's one of those things like that if it undermines the outcome, undermines the confidence in the outcome. And we spent a lot of time in our brief talking about the constitutional underpinnings of this. Due process, that my client has a right to due process. He has a right to a fair and impartial prosecutor, and we don't think that's happened in this case. And so I think that would be more along the lines of the appearance of impropriety, and then actual impropriety is receiving money,
hiring your lover.
receiving money and not paying it back. And there was testimony about that. Ms. Willis came in and testified, and Mr. Wade did, that she paid him back in these sums of cash, but there's no records of any of that or where she got it.
Anything shows him depositing cash or
No,
receiving cash?
no, and we asked her like where you got it. She said that she said she borrowed it from her campaign. So, she said the original large sum of
took it,
cash
I
came from her
thought.
campaign.
Yeah,
I
took
think
it.
all of
Took
us
it.
up here that have campaigns know you can't take campaign funds for personal use, right?
I'm not
Yeah.
well versed in that area of law, but that is my
It's
understanding.
pretty
Yeah.
black and white.
That's
So
what
she
we thought.
testified that she took that the majority of the cash she had on hand was from her campaign, that a loan she had given herself from the campaign. She was very clear about that. And then she also
Also got
said
it-
that when it got low, she would supplement it by getting like $50 back at Publix. But I mean, she's giving him, $4,000, $2,500, so large
Yeah,
sums
right.
of cash. So, and there's no trail, obviously.
Cash
There's no-
back, yeah.
There's no.
Took some
record
cash
of
back
any
with
of
that? Yeah, right.
In some of the documents you produced to us, there are a couple of IOLTA trust accounts. Those were Mr. Wade's accounts?
Yes,
Okay, so he had more than one trust account in his law firm?
yes, he did.
And did you find any discrepancy or whether these funds were deposited there?
Very special
Yes,
rules
and,
for lawyers
so
for
he
these
testified
accounts.
because we asked him where he deposited the funds.
And these are the funds where his paychecks basically from Fulton DA's office?
Yes.
Okay.
At first, he deposited them to his joint IOLTA that he had with his law partners, and then he started depositing them to his when I say personal, just him IOLTA, an IOLTA that did not have anything to do with Mr. Bradley or Mr. Campbell.
Do you think Mr. Bradley was aware that he was running the money through a separate account,
I think it might have been part of the reason that they dissolved.
that they broke up?
Yes.
Do you think his ex-wife knew that this money was being held in a trust account rather than previously it had been going through his own bank account?
His ex-wife didn't have any idea. I mean, you could tell from the pleadings that he was even making this much money. I mean, he filed some interrogatories and some answers in that divorce case saying that he made a couple $1,000s a month. I mean, very, very minimal amounts.
We knew he was making up to $35,000 a month under this contract.
Right, and he has a
Yep.
lot of money parked in one of those IOLTAs that's not disclosed in the divorce.
Okay. So that's,
Totally dishonest to his wife.
does it look like he was using his law firm trust account or his personal lawyer? IOLTA is a legal trust account, right?
Yeah.
Yes,
The interest from it goes to the state bar to help fund some
Yes.
indigent care or whatever, right?
Yes. As much as I wish we could park money in our IOLTAs that was earned and not pay ourselves, we can't do that. So
Yeah.
when you earn money, you can't leave it in your IOLTA. IOLTAs are for client money, so they're a lawyer trust account, and essentially what they are is like if you settle a divorce case, I'm not a divorce case, I'm sorry, you settle a civil rights case or a
Personal
Personal
injury case, and
Yeah.
you get $100,000, and 60 of that's the clients and 40 of it's the lawyers. It has to go into your IOLTA. It sits there until you clear the case out, you know, you finalize the case, you send a settlement letter, you get the amount, and you have to put it in your
It's like
in your
escrow.
actual business account, and then the
You hold
client
it in
gets their check
escrow
for their
until you're
part.
so
So
settle it.
IOLTAs are very highly regulated by the state bar. They can't commingle funds. It can't be earned money. It's got to be money that's not earned. And the interest does go to the state bar, but once you earn the money, you have to pay it. You have to have it in your account because you have to claim it on your taxes.
Right.
I mean, lawyers wish that they could keep money in IOLTA.
Retainer
Yes.
up front and bill against that retainer. Say, you might do that on some of your criminal cases. So, yeah,
Yes.
I'm going to take the $25,000, I'm going to put it in my trust, and then I'll submit an itemized statement and pay myself as I earn the money.
That's exactly what they do with retainers that are refundable. So they would ask, you know, $10,000 retainer, and then if this month I billed $1,500, I send you a bill, and then I take the $1,500 and I transfer it to my business account.
Okay.
As soon as it's earned, you have to transfer it.
So these funds, if they in fact came from the contract with Fulton County, should probably never been put in a trust account at all because they were already earned after he had done the work, and within some amount of time after that he sent the bill and he got paid for work that had already been done.
I mean, if they were put in a trust account, they would need to be transferred quickly.
Is that the kind of
I don't do that, but
ethical violation that can get you disbarred?
they highly regulate the IOLTAs.
Yeah,
highly
very
regulate.
strict.
I mean, the state
Money,
bar.
money,
like
money.
there's a list of places that we can do banking because they're regulated by the state bar. I have to go in person for most of my IOLTA transfers. They're not something that I can do like online banking. I mean, it's a pain.
Very strict.
But yeah, so they're highly regulated, and you were deposited in his IOLTAs because the back of the checks for Fulton County show where they were deposited.
And have you asked him about this? Has he given any explanation for why he ran this money through a trust account, or is it still in there? We don't.
I mean, the last I knew, he didn't give any explanation. I mean, he just said that he pays for everything through his business, and then he basically just said his accountant figures it all out.
Okay. I know you have a court appearance this afternoon. You've
Really
been very
good stuff.
patient with us. I'm going to give Senator Harold Jones an opportunity to ask a few questions. In our rules, we do allow at least one member of the minority party to participate. And Senator Jones,
Oh,
you're
good.
not
Oppositional
time
questions.
limited.
Good.
When the buzzer hits and you've got to go to court, you
Okay.
tell us, but I feel like we got at least 15, 20
Oh, you
minutes or
definitely
whatever.
do, and I'm happy to answer any questions you have. My court's at 115 in Fulton County, so, if I get in trouble, if you can call the judge, then I'm fine.
Number 9, Mr. Chair.
You got it.
I was in front of the Senate. Sorry.
I just want to
Judge.
go back to the issue about the conflict, because I think that's kind of what brought us all here to some extent. On one issue, in your brief, the most recent one that you filed,
The second one?
right,
Okay.
on page 21 of that, you went ahead and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative. In one court, of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath?
Right.
The oath issue. So Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed. And in and of itself, that's not, not filing an oath, that's not going to get rid of a case. That's not going to disqualify in and of itself.
Paperwork
Clearly,
problem.
The judge told us that in the
Right.
order. But I was trying to paint the entire picture and how I felt that it was relevant, and it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship, and all the evidence indicates that.
Right, and I was just kind of showing why I'm moving on to this next particular point
Okay.
here, which goes to
was
page
that
24
about?
of your brief, which deals with, I think, the thing that's really out there in the media,
Totally
which deals with
relevant.
the relationship and aspects of that some kind of way this creates a conflict of interest. And, of course, the judge is going to rule on that, but I still think it's important to kind of go through it. And you cite the case of Whitworth versus State.
Oh, gosh.
What in that case actually applies to this particular case?
Oh,
I don't know if
gosh.
I'm looking, you said it was the last one that I filed?
Yeah.
He's asking her
On-
gotcha
so February
questions
9th,
about.
Yes, page 24.
Page 24, you said Woodward?
Whitworth.
I don't see Whitward.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
Say, I don't
That's not
recall.
my page 24. You must be
I don't
looking at a
recall.
different.
Pull up Terrence Bradley. Oh,
the
that
one was
case? I don't
filed
recall.
February 9th at 3:47.
Ms. Berger, we We can't hear you.
I'm so sorry, I'm
Just
so
pull the
sorry.
microphone
Yeah,
just
of
a little bit
course.
closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
Okay,
Okay.
yeah. One that's a little bit more, okay. So that one there on the Whitworth case.
He's
Tell me
asking
how
about
that
law,
actually
like the
impacts
case
this
law?
particular case.
Which page are you referring to?
Page 24.
Page 24, okay.
Okay, so this guy's like grasping, right? He's trying to grab some low-hanging fruit, some stuff
the
that he
site
can.
is Whitworth. The court recognized a conflict of interest as a ground for disqualification, held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me.
Yeah, thanks for
but
asking her about that.
essentially, to answer your question, that first of all is physical precedent only. So
Right.
yes, and we
But you did cite it.
and said that
Right.
it's physical
Yeah.
precedent only.
And you're using that as the basis really to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict.
It's a matter of first impression in Georgia.
Sales, which deals with contingency fee.
Right.
And so in Whitworth, and I have the case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right. The
Number
judge would
one
do
would
that.
be if he had or prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on. It was, I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other
remember that.
defendants. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
Yeah.
And then they came with the
that.
third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical precedent only, and I don't remember the specific facts of that case, but it's not just a conviction. And obviously,
I understand.
the state wants it to be just a conviction, and we argued this extensively over 3 hours, I think, in front of the court, but it's also a personal stake in the prosecution, and that was an amusement, prosecution. In that case, that was a contingency fee case, so
That's
that was
correct.
completely different, yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake, actually really in the conviction, because they only received the contingency fee when the conviction happened.
Nathan
So what
Wade
you're
will only
really
get
saying
paid
is
if
that
there's
they had a
prosecution
personal
going on.
stake and just bringing the case, because he can't have there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture action.
Correct, but they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the
They
key.
get money if they
Same with
keep the
Nathan.
forfeiture. So it's where, that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right, but
That's
you-
the only way they get money.
Yes.
They
you
don't
have
get
to have
money for
conviction.
bringing it.
So I just wanted to make sure it was clear.
Right.
That was not conviction because you can't have a
But
conviction.
they only get money if they're the victor.
in
He's receiving
amusement.
his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
If he dismissed
Not
it, he would not
because
be able to
he
bill
wins
anymore.
a case.
No, he can lose the case and still
Absolutely.
make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, oh God, that's a long answer. The actual conflict is lying on your disclosures about how much money
I'm
you
talking
got
as far as
in
this issue is concerned right here. When you use the Whitworth, you use amusement sales, and they say that there has to be an actual conflict. And amusement sales, and let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor
This is so petty. It's
that they
grasping.
want the case to actually resolve in a conviction. Because
Wanna
what
argue
happened
a
was,
case?
the defense attorney came to the prosecutor and said, we would like to plead. And the prosecutor basically said, no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. They said that still is not an actual conflict, even though someone told that prosecutor, we want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
Can you point to any unfairness in the trial that's taking place?
It's not in the trial, so it's not limited just to the trial. But to answer the first part of your question, when you were asking about the conviction
you,
of
Ashley.
personal mistake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said, no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said he wanted to extend the case out, he was actually trying to end your client's case,
With a $5,000.
but it was going to end.
It
He was
would.
be no more. It would be no more billing on that case because earlier you
Just
said,
mine.
but earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the
Crazy.
one who's continuing the billing.
I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said.
So you should just
I
plead
believe that they
guilty."
created this case against my client.
What a stupid question.
So they can continue to bill.
Not
Well, he
just my
basically went out and said, I'm tired of billing. I'm going to Amina.
Okay, let
And
me
you said no.
take a couple notes
You
because
should
you got a
just plead
couple questions
guilty?
in there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer. So what I was trying to explain, and I'm glad you gave me this opportunity to sort of go into it in a little more detail. I tried to explain that there are really three classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in DC. Then you see the electors. Then you see coffee. These cases could have been
Ms.
handled.
Merchant, we can't even hear you.
Oh, I'm so sorry.
Just pull
I
it
didn't-
up right to
sorry.
you. Pull it to the
We
edge
can
of
hear
this
that
and
other
have
dude
it so
breathing.
I can
Okay.
hear.
Sorry.
He's breathing in the
So
mic.
how I was trying to explain it is I separate this down into three different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group in the middle, by putting them all three together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, we litigate that. They expanded it to include these three different classifications. What does that do? That means the trial is going to be a year. They can
19
plead people out.
co-defendants.
They can plead Michael Roman out. They can plead this person out. They can plead people
Ellis,
out.
Powell,
but they're
Chesebro.
always going to have that large enterprise. And it actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because
Yeah.
he's not gone. The deal's not, you can plea out and you're gone. Bye. We're not taking up time with you.
Nicely
it still
done.
expands it. So it's still, so
that
my whole
make sense,
point earlier was that this
Senator?
expands the litigation. Because imagine if we just had, like you see in one defendant. You can limit the information to just that crime and that case. Or you could have three separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to try them, to have three trials because there's no courtroom that can fit all of those people. So that expands the litigation.
And if
So
Nathan
in the
dismissed
case,
it,
in the case that you cited, physical or
oh
not,
gosh,
Whitworth?
Whitworth, it says specifically that when the prosecutor goes up, Morgan, who is the person who's not supposed to, who's talking to him, who's the prosecutor, Hobbs informs Morgan, who is the prosecutor, that he anticipated a successful criminal prosecution, but that any decision regarding Whitworth's proposal to Morgan was Morgan's to make. Morgan decided to continue to go forward.
Why
And
is
they
he
said
asking
that
about
that was
case
not
law?
a conflict, that was this prosecutor's decision to make. And you're saying this is the case you cite. Well, in your case, they actually came to you and said, we're willing to give you a plea. And you said no, which is perfectly
Ridiculous.
fine. But then you say, well, they want to extend prosecution on my client. They were willing to cut it off. And
They weren't
so
willing to
therefore,
dismiss
the case
it?
that you cite is totally opposite than what the
No,
situation
man.
that you're dealing with.
They didn't
How would
dismiss
you
it.
say that you have a conflict in this case?
Wild.
Based on this case, just based on this case. That was your first case that you cited in your brief.
By defending your
I
client?
don't think it was actually the first case, but
The first was actually a federal case, but the first Georgia case you cited was Whitworth on this particular issue.
right, on this particular issue.
Correct.
And again, I don't have Whitworth in front of me, and there's a lot of different facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's enough to have a personal interest. So what we've got is we've got these financial disclosures where they're not being truthful. Ms. Willis is lying under oath, which is the same thing my client is charged with conspiring to do.
Yeah, weird.
Lying under oath about
Only one
receiving
gets
a benefit
prosecuted.
over $100. So you've got those. You've got this concerted effort, which we have seen, unfortunately, drag out over the last couple months, this concerted effort to hide this information from the public, to
Yep.
keep this information out. I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And Whitworth, the problem with Whitworth, and this is
Who actually brings the case?
the district attorney. Well,
How did they get the case?
well, we know a lot more now because of the book Find Me the Votes. So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Wade. So the one that he presented most of the witnesses,
How was your client charged? How are these clients charged?
My client was charged just in the actual grand jury.
Okay,
Yeah.
so grand jury.
Yes.
Okay, so we had a special grand jury, and then you had a grand jury
Yes.
who made this determination.
Well, yes.
They made a determination to bring charges, basically, to indict, correct?
Yes, and I.
So are they part of all of this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this, it is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident.
Yeah,
And the
Joe,
grand jury
You
indicted
could
him.
indict a
saying the
ham
grand jury
sandwich.
has
I hear
flaws?
about that all the time. Yeah.
100%.
Oh.
Yes.
So would you think it'd be better for just the prosecutor to draw the accusations?
No.
So the
and
grand jury-
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight.
Correct.
Definitely, but
Right.
it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is. I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury
It's
is
not.
one-sided. They only hear from the prosecutor. And they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. The prosecutor brings that indictment, and then they vote, and it's a majority. So all they have to do is a majority vote, and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally, you've got a standard of 25%. I think there should be much more safeguards on the grand jury process personally, but that's for another day.
So it went through special grand jury and they made their recommendations. Then went to a grand jury and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3?
Two or three
And they were
already.
there was one, so the first gentleman who pled, he was a bondsman, and he was not, because of
Paul
the state law
Chesebro
for
Powell
bonding
Ellis.
agents, he's not able to act his business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he
All
didn't enter a
diversion
plea.
deals, too.
And I mean, he got probation. It was not not what you would imagine in a huge racketeering case. You would not
No.
imagine probation and a $5,000 fine. The other 2 people who pled are both lawyers at the end of their career.
Jenna and Sydney.
I
Sorry,
can
Jenna
imagine
Ellis.
when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking
Jenna
about
Ellis
is
blown
Mr.
out.
Wade's kind of qualifications. So,
yes.
But you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills, yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive recommendations, I
Anyone
guess,
could.
from state side.
Yeah.
He's able to go to a grand jury and get indictments, which positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
That would be up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying, I mean, when you say that someone's totally unqualified, that's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral
Oh,
in
that's
that.
not surprising at all.
And he's going into
not
a grand
surprising,
jury.
yeah, you could
say
put a
he's integral
7-year-old in
that.
front of them.
Then why even say that he's unexperienced? And he's getting people to plead guilty. And but basically you're saying those are
They're
just
diversion
lawyers
deals.
that don't want to do anything anymore, and they just play.
They're all going to be dismissed. They're getting no convictions.
No. So the special purpose grand jury, first of all, remember, my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So he did that, Wooten, and he never did it all by himself. He definitely led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not,
But when a person's trying to insinuate that somebody's basically totally unqualified, it is important to realize that they've walked this case to this particular, very complicated case, I'd imagine.
This is also a
I
minor
mean,
issue.
that's something that we could debate. You know, if walking someone through the grand jury, the special purpose grand jury is complicated or not. You know,
Not complicated.
Asking questions, and again, there's a team of 10 lawyers, so
So now there's a team of 10 lawyers.
who knows what part he's doing. But the question would be then, why him? Why not all of the public servants who are
Yeah.
taking government salaries and, you know, restricted in their private law practice? Why do they need him there when there's all these other people? As far as the qualifications, asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent. There's no adversary. There's no judge.
Once it became adversarial, you've had persons start
And-
pleading. And maybe more potentially, correct?
To diversion.
Possibly. But we'll find out.
Diversion.
Doesn't
But let me ask you this, though, because you're talking about the staff. One of the reasons you may go outside to outside counsel could be the fact that if you actually put this type of case within the office, just speculating, but to some extent, we all are, the office would basically shut down. It's a
Especially
potential that
Terrence
the
Bradley.
DA's office had actually basically shut down.
Oh, God, no. If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you had 5 new inexperienced ADAs, they're not tackling this case. And also,
Well, the inexperienced ADAs are not going to make
He's going to-
$200,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what
But
they're.
the key thing
For
is
50 to 60
that
grand,
job that you're talking
not
about that you're going to
150.
hire with that, with the $1 million that you'd have paid him.
Yeah.
If that's your theory on it, that's not going to stay. That's not necessarily going to be long-term if you're just saying the money you paid him, you could have done this. Because his is a short-term kind of situation.
They
His
had
is on
appropriated
contract, so it's
$5 million to
short-term.
those new
It's not a
DAs. That was
long-term
COVID money.
contract. It's not going to last for a person's career. So
They-
I
they'd re-up
understand
it
the
the
back and
next
forth
year.
when persons were saying, well, they could have used this money for that. But that money was delegated for him on the short-term
No, it was not.
project, so to speak.
No, it was not.
So it's not anything that a person would come
was
in
delegated for
long-term and
COVID
actually necessarily
and the
do.
backlog.
But at the same time, that would be up to the district attorney to make that decision, how she's doing that. I just make the point that so far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about
They
what's
shouldn't.
qualified, what's not, but
How much
certainly
jail
I
time
think
did
that
they
they would
get?
argue at
0.
this point the case has gone from a successful pattern for somebody that's been said
Single
is totally
conviction.
unqualified.
They're all going to be dismissed.
I do
Every
wanna
one of
go
those
into these
convictions is
trips.
going to be
How much was
dismissed.
the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond if it is.
Yes.
Please.
Okay. I took notes because there were a couple different questions in there. So
He's
the
just
first
ranting.
one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, you know, Unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this. And I
Wrong.
just wanted to make sure that my testimony was accurate. This money was never delegated for this. The
Never.
county did not ever delegate this. The county was not involved in that at all. Ms.
Senator.
Willis is the one that decided, and there's no like budget. There's no transparency at all on this. The
She
other,
does the contract with him, and I believe you showed those contracts. So in that sense, is delegated to him because that contract can end at any time. She could say, "Hey, the contract
Yes.
because he works at her pleasure."
Oh, yes.
So that contract can actually
Yeah.
end at any time. That
Yes.
Yeah, he
would be the
definitely
point.
works at her pleasure.
Um,
You're right
on
about
the
that.
trips, how much
Yeah,
total were the
gross.
trips?
about $20,000.
And I think it was about 17,059. But even if we say 20,000, what was the average cost of each one of those trips?
Oh, gosh.
Well, if
You
we-
know, unfortunately,
They were
they
low
did not
cost?
provide all of the records, so I can't tell you exactly. All I can tell you is what Mr. Wade charged on
He
his
got a good
credit
deal.
cards. I can't tell you, most of it was paid in cash, so there's no record. So I wish I could tell you, but
Going by your slide, one was 3,335, one was 4,453.
which one? Hold on, I want to make sure I'm clear.
6 trips.
Okay, but which trip are you talking? Well, you said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up. There we go.
Okay.
So the first one, Royal Caribbean, 3,335, Aruba, 4,453. And then we see the next one, and then the next 2.
Is he going to say that those are cheap? Those are good deals.
How would that compare? I mean, what is that
He is,
so
isn't he?
unusual on price points so far as trips are concerned?
No, I mean, I don't think so. The Royal Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabin. So they had 2 cabins. His mom had a cabin. They had an oceanfront balcony. For the Bahamas, I think oceanfront balconies probably.
They got good deals on their
upper
cruises,
middle, but I
so
don't know that it
therefore,
matters.
no problem.
Flew, comfort class, not unnormal for a lawyer. I mean,
You know what maybe the average American spends on vacation?
not this much.
Not
You
that
think?
much.
No.
Have you looked?
Huh? No, I haven't, but I would imagine most of the Fulton County taxpayers would love to go on any of these trips.
Well, if you, since you speculated, I could speculate and say that you did look, and that's why you didn't put it in your brief.
I did
Because
not.
Forbes actually says that the average is about $3,700 that a person spends on a vacation.
For a single person or a family?
Family of 4. At that time, they were taking 2 and 3 at the time.
Are they going on
So
cruises?
that makes, that's about
No,
normal.
hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on,
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said 3,700 for a family of 4.
What a
That does not
stupid
surprise
line
me.
of questioning.
For families that can afford to go on vacations, doesn't.
Basically what the average American would do.
So
Yes.
this is half of that for 2 people. So you said 3,700 for a family of 4. This is for 2 people.
Right, it's just 2 people.
And do they go 4 times in a year?
That,
Do they go?
Yes.
Do they go
So
20,000 a
necessarily
year?
average, it's 2 adults. Bottom line is it's not extravagant. It's not lavish, is it?
the law only says $100, so.
But it's not
That's,
lavish.
and that's one of the reasons I
Sounds
didn't.
pretty
include all
lavish
the
to me.
Ubers. I quite frankly didn't want to do the math, but there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamas.
Restaurants,
I didn't include that.
food,
I didn't want to do the math, and I
massages.
also did not want to.
And how much does
Shows.
this make?
200 and something thousand a year?
So
It's in my brief.
your argument is that a person who makes $200,000 a year
Mm-hmm.
is actually setting up prosecutions to go on a trip that costs $3,500.
Yes, she likes Grey
That's
Goose.
right.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about in
isolation.
isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm saying is that I've got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip with $3,300, $4,400. And they have made up all these prosecutions to go on a 3-day cruise for $3,300.
They went on
That's your
multiple
argument.
trips.
That's your argument. That's your argument.
That's not.
That's in the brief.
That's not our argument. So, we did
What else
argue
is
for
in the
about
brief?
3 hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can kind of assume, because it's from the airport to the hotel, but I did not
They're
want to
both in
speculate
it.
to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are on
That's what's in the
trips.
brief.
Yes, the ones that I actually had hard numbers that I knew that she had. Yes, that's in the brief.
In our business, we deal with proof, and so that's the proof that we have.
Exactly. That's
that
why that's what I
That
did.
person
Yes.
is doing all of this for that.
Right.
Okay.
Oh, yeah. And
Understand.
so what I included was what I had the actual hard proof of. And then some of it's attached to the brief. Some of it I got by subpoena. So some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted. And there were a lot of other receipts that I had that I did not know for sure if they were joined. And so I didn't include those. And I haven't
And you
talked about it
shouldn't,
today.
correct?
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff
Okay.
that's hard proof.
Correct. That. So my next question then
Wild.
becomes, going to conflict as far as his salary is concerned, just curious. Is it the amount of salary that you believe creates the conflict? I mean, because we get stuck on
Not
money
really.
a lot. So is the
Yeah, not
amount
really.
of salary that is creating this conflict in your mind?
No,
Or
it's
it's
the
just the
fact that
fact that
they're-
he gets any salary at all?
No, it has nothing to do with that. I did not make any allegations against Mr. Floyd or Ms. Cross. It's the fact that they were sleeping together and he was
Yeah.
paying for trips for them to go on, and they were
Yeah.
hiding it from the
Discussed,
taxpayers.
Which we just discussed that.
That's why.
So if there's not a trip, then you don't believe there's a conflict?
Oh, I do, because of
That's
the Fulton
not-
County laws. The laws say that they
I'm
can.
talking, I don't understand the county codes. But I'm
I don't
talking
care
as far
about
as,
the
like,
law.
what the case law says, which is
Oh, yeah.
what the judge is actually going to. If there's no hiding that or against the Fulton
were.
County ordinances.
They were
do you
hiding it.
believe- Do you
They were.
believe that there's a conflict? If they brought it out and said, hey, we're dating, is it a conflict in your mind?
They only brought it out once I alleged it, and they called me a liar multiple times.
What I'm saying is if they brought it out, would it be a conflict in your mind?
If
Is it
they-
a conflict?
Here,
yes.
in a-
And what would be the conflict?
So in a perfect world, what you're asking is if Miss Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election
So
interference
good.
case.
Well done.
Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the safe house
Well
that Fulton
done,
County's
Ashley.
paying for, and he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J,
$780,000.
knowing that, Exhibit J, we wouldn't be here.
Rub his nose in it. Well done. How'd you like that
So
there,
then your
Senator?
client actually has no conflict, because that would still exist.
That
Your
didn't
client
happen.
has no hard conflict then.
That didn't
There's
happen.
no actual conflict. It doesn't matter if she disclosed. A conflict, if you disclose a conflict, it still exists. And that's exactly what they said in one of the cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you, and I have a conflict, and I'm going to go testify against you. Conflict is now over. Absolutely not. If you have an actual conflict where your client is harmed, just because they disclose it doesn't end that conflict. So what
No.
you're describing is not a conflict at all. You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You cannot waive a conflict like that. You
No,
just could.
so-
If your client is,
This guy's
you could
just
not
talking
do
in
that for your own
circles.
client. If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm, but she said it, so we're going to still go forward.
What
That makes
the heck did
absolutely
he
no
just
sense.
say?
I'm sorry, I don't understand your question.
Yeah, no one has any
I don't know
idea.
You
what you're
don't have a conflict if you're saying if she disclosed it, it would go away. Then there is no
No,
conflict.
no, no, I did not say that. I said we would not be here if that had
Yeah.
happened.
Right,
That's what
because
I
you
said.
wouldn't claim there's a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes.
It would have
and
never
ordinances
happened.
And the state statutes, that we wouldn't be here because it wouldn't have been approved.
Right.
But if she disclosed it, not the way you said it.
No.
But if it was disclosed,
hold
it's
on.
disclosed
If
now,
she
what is the
disclosed
conflict?
The undisputed facts, the facts that we all, your side, my side.
How is your
whoever's-
client harmed? That's my question.
Hold on, I'm trying to answer your first question now. So if all the undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract. Because
would
it's
not
in
have given her
contravention-
one.
Contravention of law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the grand jury. He should not have been there. He should not
Well
have been
done.
appointed. Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what
And what,
could have
what
happened.
case law do you point to prove that?
Oh, the statutes. It's
No, it's not a stat, not Fulton County statute. I'm asking for Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says that? And there's not.
no, and it's really not surprising, honestly, because can you imagine this happening? I mean, honestly,
happens.
in December, would you have imagined
it
this
doesn't.
happening? I think most people wouldn't
All
have.
sorts of
A DA?
conflicts are taken up by the Court of Appeals. and
I can
Supreme
tell
Court.
you, I have found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor appointed, because it's the only place that this happens.
There's no
So
precedent.
Otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting counted, not
Is she
filing.
paying him, or is he earning the money because he's actually billing hours because he's prosecuting the case?
I mean, I don't,
He's
I wasn't
billing hours
there.
because he's prosecuting the case, correct?
I
A case that a
assume- I
grand
would
jury
hope.
indicted.
We don't know. That's the
I
problem. We
would
don't know.
hope that he's billing based on work that he's doing. I don't know because I don't
Right.
have proof of that, and the billing is very irregular. But I don't know, so I don't.
But I
wanna
mean, words
speculate.
do matter when we say that she's not paying him in that sense.
She gave him
He's
the contract.
if he's earning money for a case that he is in charge
She
of
approves the
prosecuting,
bills.
that a grand jury indicted.
Okay to
and
pay.
That's where we are.
You're
That's-
correct. She is not paying him. The Fulton County taxpayers are.
As they pay every prosecutor, as they pay every public defender, and every government official that actually exists.
Yeah,
Employees,
100%.
yes.
Yeah,
that
the
he
ones-
is
the
part
ones
of
who
that
don't sleep with their-
process.
their
And he is
staff.
prosecuting a case that you're involved in, correct? He's prosecuting, and he's been integral in that prosecution. And you've said that.
He has
I mean,
been
he has
integral.
been very involved. Integral to me means that he is necessary.
Okay, good.
Senator Jones, are you getting close?
Yes, sir. I just had one last question, and that was, in the case that you cited, it clearly says,
Which case? I'm sorry.
in
Witten?
Whitworth versus State, it clearly says, the prosecutor should see no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay, fine.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people on visual. I like to see it. Do you mind? Thank you.
This is so lame. This guy is trying to dig into case law. He's not a judge.
While
he
she's
gonna be
looking at
considering
this, we're gonna
statutes or
wrap up
something
here
to
in a
pass?
few minutes. I wanted to let the public know how you can get information to us. Each
Yes.
senator on the committee has a separate email address for committee business, and it's simply the last name of the senator. In my case, it would be calcert.inv@senate.ga.gov. INV, obviously, for Investigation Committee.
If anyone
Each
else has
senator,
any,
their last name, .inv@senate.ga.gov. And David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will be cook.inv@senate.ga.gov. I've had a number of citizens that have reached out and wanted to provide information or be heard or testify possibly in front of this committee. And we are encouraging anybody that has input or information that might be helpful to us to provide it to a committee member, ideally to cook.inv@senate.ga.gov, because Secretary Cook will provide it to all committee members.
amazing. Any Georgia
We don't
whistleblowers
have
out
a,
there?
Next meeting scheduled yet, but it will be no more than a couple of weeks away. Ms. Merchant, you may not be able to have completed your testimony today, and we may have to call you back for additional questioning after today, but I'm not rushing you. Take your time, read that.
Can it not be the first week of April?
Yeah,
Cobb County spring break, please.
that'd be fine.
Thank you. Okay, yeah, no, I'm so glad. So this is Morgan. When you said Morgan, it should have, J-Tom, it should have struck with me. I remember this now. So this case, so J-Tom was actually the district attorney when he first took this case, and he was not.
Don't talk, wait.
Oh, I'm sorry, I forgot the microphone. I'm not good at that, sorry. He took employment later on. So the employment, so it's different than our case because he took employment later on. He wasn't actually paid hourly. He's a member of Prosecuting Attorneys Council. And I'm glad you brought that up because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it. And that's what happened in that case. But they sometimes will pay an hourly rate if it's something that is needed. But in that case, he was actually the district attorney in another county. And that's what I've experienced before. So the 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then he took a job later. The other big difference with that case, and this came up in our oral arguments with the judge, that's a post-conviction case. The standard of review is very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish that. That's the big issue, and the judge pointed that out. That is
dump
post-trial.
all
Post-trial,
over
we
this
have
guy.
harmless error review. It's not a great review. So, it's just like ineffective assistance of counsel. If you stop the harm before it happens, it's a different review than if you fix the harm after it's already done. It's really hard to overturn a conviction once the conviction happens, and that's what you have there.
In this case, they never got to the harmless error because they said that no conflict existed. I understand what you're talking about by the harmless error, but they never discussed that because no conflict existed. And you're right, it is post-conviction, but bottom line is you really did not address the aspects that I was talking about when they say is a conflict. And it's not me putting this case in, talking about a conflict. It was the case that you guys actually did cite. With that, Mr. Chair, I yield.
Well, can I at least answer that question?
Sure you can.
We definitely cite it because we have, both myself and my husband have a very strong policy of citing everything. We don't hide cases. So if there's something that's adverse to our position, we're going to cite it and we're going to explain it. We don't hide behind it. So we cite adverse authority all the time.
So good.
Adverse authority, but that's fine.
The oral arguments that we did, that was how the oral arguments started, so.
Amazing.
So that line of question deals specifically with the legal principles involved in your motion to disqualify. As I understand it, you're not really claiming a conflict of interest between defendants, et cetera. It's the conduct of the prosecutor.
Yes.
That
Yeah, there's
is
no
improper
conflict.
conduct.
Yeah, we're not talking about the conflict between defendants.
We're talking about the fact that the DA's office failed to follow state law and get an approval, failed to follow county policies to get approval of her budget and this contract, that he was not eligible to have been hired had he been disclosed because of, you referred to it as nepotism, but it's relationships
Yes.
with, and your complaints are of she's receiving a financial benefit of gifts of more than $100, which violate county policies.
Yes, county and state. So,
That's right.
and we attached that to one of the briefs, her return where she filed it under oath that says,
Okay.
I mean, it specifically says if you've got something over $100, you have to disclose it.
And
Oh, here it
then-
is. It's, so it's called the Fulton County Income and Financial Disclosure Report. And that says, and it says pursuant to Section 2-79 of the Fulton County Code of Ethics, that anytime you've got each gift or favor from a single prohibited source in the aggregate amount of $100 or more. And then it says, purposes of this section, gift and favors means anything of value given by or received from a prohibited source. Prohibited source means any person, business, or entity that the involved officer, so Ms. Willis, knows or should know is seeking official action or is seeking to do or doing business with the county. So obviously that would apply.
Okay. And failing to respond to your open records request and potentially giving false testimony under oath if your version of facts is proven to be true.
Yes.
Okay. keep us posted. I guess we'll keep reading the press as to how your case progresses, I guess there. I'm troubled about this Find the Votes book. Are you saying that the prosecutor has been discussing an ongoing prosecution and her
Yes.
prosecutorial strategy and indictment
Exactly what he's
strategy
saying.
to authors of a book during the course of the prosecution?
Yes,
And
yes.
that book is now come out?
It is. It's,
And
I don't think I brought it with me. No, I have a copy. We admitted a copy at the hearing. No, it's out there. It was published, you
Is
know.
that a violation of ethical obligations in some way to be publicly discussing, just like the public statements you made about the guilt of a defendant, et cetera?
Yes, definitely. And we alleged that and argued that as far as forensic misconduct. It's very surprising, shocking, and, you know, I don't know that there's a ton of cases on it. But that book, also, we talked about it somewhat in our hearing because it goes into a lot of details about the financial troubles that Ms. Willis had prior to becoming DA. And so, you know, it talks about that a lot.
Okay. Is she getting a financial benefit from that book?
I don't know.
Is she getting a royalty or payment for having been a contributor to it?
I have no idea.
Okay.
But I know her dad testified that he was interviewed for it. He came to the district attorney's office and was interviewed for it as well. And I think that was when her dad first learned that she had dated Mr. Wade, I think. But I may be wrong. Or maybe that's the first time they met, something like that.
All right. Well, thank you for your willingness to testify before us, and the documents you provided. We'll need some time to analyze and review those. And again, all committee members have access to those. At David Cook's office, he's got them literally locked up in a room. We are not making copies or disseminating those. I will review the documents in more detail, and I'll confer with you, Senator Jones, if you're able to. We might can agree on what should be kept confidential there. I noticed some bank records and things that if it were me being investigated, I probably wouldn't want it divulged to the public. I don't think that's necessary for us to do our job here. I do appreciate everybody's attendance, and thank you all for making time to be here on our committee day. We'll keep you posted further meetings. The meeting is adjourned.
Well done, Ashley Merchant. Oh my goodness, my friends. That was a heck of a hearing. And so they are done. The Georgia Senate wrapping up a pretty incredible hearing. Ashley Merchant did just an outstanding job. And let me get the screen and everything resituated, get the tubes reconnected. We're going to do a debrief on everything that just happened. And then, of course, we're going to jump in and hear from you, get your questions and your comments and all the things that have been going on out there in Fulton County. So absolutely incredible. Let's get.
All right, y'all, man. I want to thank Robert Cavea. It sounds like he's having audio issues, man. So I want to give a shout out to him. Man, I don't know who that damn clown was asking Merchant all them silly, irrelevant questions, but I like the head guy. You know, good information. I know a lot of people were watching. Man, shout out to everybody in the chat. Shout out to Kelly. Shout out to Callie. Shout out to, I think I saw Twin. Did I see Twin? Yeah, I saw Twin in here. And I think I saw Josh too. Did I see Josh? Tim was in here. Twin, Deacon. Did I see Josh? So so Tim is in here, but I thought I saw Josh, man. Wasn't sure. Like I said, I know it's early in the morning for some of you guys. Man, shout out to Cali. I know it's 6 o'clock in the morning in California. Yeah, man, this one, and like I said, tomorrow is going to be the Fulton County Commission's hearing. So yeah, like I said, Fannie Willen being disqualified from the case is just the beginning. It's just the beginning. Like I said, we're going to go through we just went through the Senate. Tomorrow we're going to go through the county. So the Senate is a state. because the state is interested in state funds. The county is interested in the county funds. So you got state funds, you got county funds, and you got federal funds. And then when you got state, federal, and county funds, you know the IRS, their ears are going to perk up. The IRS is going to be interested, and of course the ethics, they mentioned ethics. Ethics board is going to be interested because they don't like lawyers showing their asses. They don't like lawyers doing the fanny call. Today we're ending the word booty call. We're no longer going to call it booty call. We're going to call it fanny call. So what did Callie say? Callie. Yeah, I think we still got Kelly in here. It shows Wade was already on the case. That's a fact. Even though they're bogus interview process, right? I can't recall. I'm gonna have to rewind. Yeah. You know, Callie, like I said, you know, it's early, but hey, this is why I did the stream. So, you know, we can go back and, you know, check it and all that. But like I said, this is just the beginning, sis. Wait until, hold on. Wait until the one tomorrow. I can't wait till she gets before. Now this one was good. The Senate is good. I can't wait till the like I said, this is answering for the state funds. Tomorrow is going to be the county funds. I can't wait till they get to the federal funds, man, because you know Marjorie Taylor Greene gonna be on there. Oh man, she going woo. Marjorie Taylor Greene gonna be on it. I think this Senate here was pretty nice. You could tell the guy was very interested in what was going on. So yeah, true Southerner too. You could tell he's like, damn, I wanted to give a quote. He's like, so does this mean it's a violation? Hell yeah, he was into it, boy. I said, oh yeah, I like this guy. So please be kind. Please be kind. Rewind. Oh yeah, that's an old school. That's an old school blockbuster. Oh yeah, you old school. Please, please wait. Please be kind. Rewind. That's an old blockbuster. That's woo. You're telling your age, Callie. That's a blockbuster saying. You know when you rent. What was it? DVDs? No, not DVDs. That was hell. That's VHSs. And they say be kind, rewind. Boy, that's old school right there. Shout out to Callie. So Callie said, don't forget campaign. Yeah, campaign funds. That's going to be actually that's the Senate. That's either is that the Senate or the state? Wait, is that the state or is that the county? I think that's the county. When they talk about campaigning, that's the county funds. So tomorrow, the Fulton County Commission, they're in charge of the campaign funds is the county, if I'm not mistaken. It could be state, Cali. You know what? I think it's county though, but because I think each county is responsible for each campaign fund because they campaign for the county. So I want to say that yeah, the county, the Fulton County Commission is going to want to know about those campaign funds. So yeah. Like I said, you got county funds, state funds, federal funds. So yeah. So this is the state. Tomorrow's going to be the county, and then we're waiting on the goddamn House Judiciary. That's going to be federal funds. So yeah, man. Woo, we got a lot. And like I said, we still got the ethics board, and then we still got the IRS. They gonna be interested in it. Oh, did they go? You know, IRS gonna want to see receipts. Okay, so Kelly said, Kelly, if you can jump on, I guess you ain't got time. Did they go to lunch or are they done for the day? No, they done for the day, Kelly. That was it. They're done for the day, but they're gonna be back. Damn, they didn't say, but you know, I'm gonna be up on it. I think tomorrow they're gonna do. They can't do it tomorrow because the Fulton County Commission wants to do a hearing with Natalie Merchant. So yeah. They done for the day. Okay, thanks. Okay. County Elections Commissions might be another hearing. Yeah, they're doing that tomorrow, Callie. That's the Fulton County Commission is the county. So what you just saw was the state senate. So that was the state senate. That would be state funds. But now tomorrow I'm going to do the Fulton County Commission. That one's going to be real good. That one's going to be real good. Let's see. Kelly said, I don't know. I just think they shouldn't leave any door unopened. They're not. They're not. Oh, no, 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 no. No, 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 no. Everybody's interested in this. The only one that has not mentioned anything, but I know they're looking, is the IRS. The IRS is the only ones that hasn't uh, said that they want a hearing. But the state said they want to hear it, state senate. Of course, you know, the state Congress, the Fulton County, the county commission, they said they want a hearing. The House Judiciary in DC, the federal, they want a hearing. Yeah, everybody wants a hearing. Like I said, the ethics board. Oh yeah, the ethics boards they want a hearing. The only ones I haven't heard from is the IRS. The only ones Callie can validate right now is the IRS. But I can more than guarantee the IRS is going to, after everybody's said and done, then the IRS is going to come in, because that's how they do. They always sit in the back and let everybody damn uh, feast on the carcass, and then after everybody done feasted, then the IRS comes in and get the bones and whatever's left over. So yeah. So Kelly says, okay, sorry, a little lost. Haven't even had one cup of coffee yet. Oh, that's okay. I know it's early. It's early where you're at. I get it. I get it. It's early. Boom shakalaka. Boom shakalaka. Yeah, I get it. It's early. Like I said, it's early for me. Hell, it's barely 12 o'clock, so it's early for me. But um, hell, I've been on here 3 hours, and when I saw it, I said, "Oh shit, they doing this quick." I thought they were gonna do this down the line. I didn't know they were going to do it so soon. So I was caught off guard. I was like, oh, shoot, let me damn. So I jumped out of bed and I damn clicked it right on. I didn't even have time to, because y'all know when I do videos, I like to put up give y'all kind of heads up. Like, okay, so Thursday, I got one called Hitler's Ghost. That's the Arena Abroad. That deals with Zelensky. That also deals with Germany, who they caught some recordings. Oh, this is gonna be a good show. If y'all are into international politics, uh, tune in for Hitler's Ghost, because that one's gonna be a doozy. Oh, and also in Canada they honored SS Waffen Soldier, and Zelensky was there. You know, Zelensky is Jewish. His wife is Jewish. His wife was looking crazy at the dude. So yeah, you had Canada, and you had Zelensky and his wife. His wife was looking crazy though. She wasn't happy, but Zelensky was honoring this SS Nazi, who's still alive, by the way, and he's hiding in Canada. And Putin wants him extradited to Russia to face some war crimes. So yeah, I'm gonna get into it. If you guys are into that kind of stuff, I'm gonna goddamn, it's gonna be like I said, it's called Hitler's Ghost. So that one's gonna be a good one. So yeah, but like I said, I'm gonna keep y'all informed. That's gonna be Thursday night. Tomorrow I'm gonna do tomorrow I'm going to do the Fulton County Commission hearing, and then yeah, we're just gonna. Man, I'm just gonna play it by ear, because like, yeah, they're on it, man. They are on it. They want Fannie Willis. They want that Fannie. They want that Fannie. Yeah, Thursday. Yeah, I think I have it in the description, Kelly. I think it should be in the let's see, FS. Now I can spell. Um, Germany owns most of Ukraine, technically. Yep, that's right, Callie. You already know it. Oh, yeah. By the way, of buying debt. Yep. You guys are going to see the whole, you guys are going to see some stuff that involves Germany. Like I said, it's called Hitler's Ghost. And, I picked the title because Putin said he wants to denazify Ukraine, and as you know, there are descendants of Bandera. I mean, there's some Nazis that are still alive. I didn't even know they were still alive, but apparently, I guess these guys were young. They must have been really, really, really young when were drafted into Hitler's Third Reich. But yeah, they're still alive. So yeah, Hitler's ghost. Man, so let me, like I said, I've been on 3 hours. Thank you, Kelly. If you do a show, let me know later on. Callie, thank you. Thank y'all for coming out. Oh yeah, Nikki Haley, by the way, stepped down. So some Nazis still alive in the USA. That is right. You absolutely right. Right. And Putin wants all of them. He wants all of them, man. Putin wants all the Nazis, man. So, and that's why we fell out with Russia because we wouldn't turn over a lot of these Nazis, scientists and all that. Russia wanted them all. Russia wanted them all, but we you know how America do. If you come work for us, all sins are forgiven. So there you go. Love you, Kels. Have a great day, Black Sun. Thank you, Callie. Thank you, Kelly. With that being said, I am going to close it out. Peace, y'all.